Mic test 1, 2, 3.
¿Cómo estás? Bien, bien.
Good morning. So we need all of the panelists.
Yes.
Yeah, but the others are, yeah. We're missing the panelists. Ah, mira. Ah, okay. Buen día. ¿Dónde? ¿Ya viste tu letrero? Sí. Do you?
Click on this side.
Yes, you're okay. So we're in the same. It's not yours.
I found mine.
It's a little bit. And just checking. So we're missing one person. So yeah, we have you. And we're missing Mr. Melissa, right?
Yes. I don't see.
Should we? We're right on time. Do you want to wait or should we
think,
start?
given the number of panelists and the time,
We
I
should
think
start.
start
with
here.
that. Perfect. Yeah, I agree. Good morning, everyone. I'm honored to start our day 2 of this amazing workshop. And we have a full house session that it will be very interesting. And I really look forward to the conversation, both the presentations from this very interesting panel and also the participations from the floor. This session, we will be talking about both the role of international and regional human rights bodies contributing to accountability and access to remedy for environmental harms, which is an essential part, of course, of the right to healthy environment. As we know, the right to healthy environment includes substantive elements as well as procedural elements. And access to information, public participation, and access to justice are both procedural elements of the right to healthy environment, but also recognize human rights. And so with this, I will give the floor. It's an honor for me to give the floor to Ms. Honorary Lady Justice Anita Mugeni, Vice President of the East African Court of Justice. Honorable Lady Justice Anita Mugeni is a judge and the Vice President of the East African Court of Justice, and also a senior advocate with over 25 years of experience in commercial and civil law litigation. In 2021, she was appointed judge of the East African Court of Justice, Appellate Division, and became Vice President of the court in June 2023. So thank you very much for your participation here, and we would love to hear from the region what are the challenges, but also the key access to justice and remedy on environmental cases that you can contribute. Thank you.
Thank you, Chair. Good morning, distinguished participants. Our discussion today focuses on the role of regional human rights mechanism in contributing to accountability and remedies for environmental harms. To illustrate this, I will draw from a landmark case of the East African Court of Justice, the African Network Animal Welfare versus Attorney General of the United Republic of Tanzania, the commonly called Serengeti case. In June 2014, the court delivered its decision, held that Tanzania proposal to construct a highway across Serengeti National Park was unlawful, and court issued an injunction to restrain the government from operationalizing the project. In essence, the court found that the proposal violated several provisions of the Treaty for Establishment of East African Community, notably Article 5.3c, which commits partner states to the promotion of sustainable utilization of natural resources and effective protection of natural environment. This decision was significant because it affirmed the environmental protection. It affirmed that the environmental protection is not just a national concern, but also a regional obligation. It showed clearly that regional courts can play a crucial role when state action threatens ecosystem, communities, or shared natural resources. Now, let me first to respond to different questions asked, or like what priority action can strengthen access to justice and remedies for environmental harms in the East African Court of Justice. I would highlight the following priorities. The first one is easing public interest litigation. Because this case to take place, it was driven by some lawyers who act as public interest litigators, so that like NGOs and communities can bring their cases to our courts without unnecessary barriers. There was also the capacity building for judges and lawyers, particularly in environmental and international law, to address technical complexities of such disputes, strengthening enforcement throughout monitoring frameworks that compel states to implement court decisions, improving access to information by publishing judgments, in plain language and in format accessible to communities. Encouraging alternative dispute resolution, and finally ensuring inclusivity by making services available in Kiswahili and in French. Here I remind that the language of the courts on English, but we are working in a way that we also use Kiswahili and French in coming years, across, so that communities across the region can easily access, because member of the East African community, they speak French also and English, but the common language throughout the East Africa is Kiswahili language. The second question concerns the challenge faced by rights holders in this case. Here I can cite three main challenges, then like political sensitivity, since the environmental issues often intersect with state development priorities, leading to government to resist scrutiny. Limited awareness, because many communities are unaware of their rights under EAC Treaty of the courts, or are not even aware that there is a court which can rule on such cases. Resources constraints, that's I think general issues in this court, in these organizations, and also litigation, the long litigation, technical, expensive, that can affect communities, so that sometimes they even drop cases. On the third case, what opportunities exist for cooperation between the United Nations and the East African Court of Justice to strengthen the accountability. There are several opportunities which can be identified, but I will here cite some. I can say the joint training programs for judges, lawyers, and civil society on environmental law, human rights, and climate justice. Policy alignment to connect ESCJ jurisprudence with international agreements and the Sustainable Development Goals. Public awareness campaigns, compliance and monitoring mechanism supported by the UN to ensure states follow through on court ruling, and lastly, knowledge sharing, so that the ESCJ can learn from other regional courts, and other regional and international courts, how to handle similar cases. In conclusion, I can say that the Serengeti case demonstrates the vital role that regional human rights mechanisms, such as the East African Court of Justice, can play in advancing environmental accountability. But for this potential to be fully realized, we must lower barriers to access, address political and resource challenges, and strengthen partnership with global institutions, particularly the United Nations. Thank you.
Thank you very much for this very important presentation that we heard, and we will hear from other cases also the importance of the regional human rights institutions to be there in order to help to advance justice in these cases, and the challenges and the difficulty deciding these cases, including when there are projects that are targeted for development, but the importance to make sure that these projects and all of them will be implemented in an adequate way and in compliance with both national, regional, and international obligations from states. This also reminds me one of the elements that we were talking yesterday about challenges, because in some of these cases, states also are subject to investor-state dispute settlement and arbitrations internationally, which also poses a lot of challenges, even financial challenges for states. And with this, we're moving to the second panelist, Ms. Mr. Nakata Miwiza, Principal Legal Officer from the African Court of Human Rights, Human and People's Rights. Dr. Miwiza is a Malawian scholar and legal practitioner who currently works as a Principal Legal Officer at the African Court on Human and People's Rights, and also in charge of the Research and Capacity Building Unit on the Legal Division of the African Court. Thank you very much, and please, you have the floor.
Good morning, and thank you, Madam Chair. Again, let me extend my appreciation for the invitation to the African Court to be part of this deliberation today. Let me quickly begin by sketching the mandate and the jurisdiction of the court so that its role insofar as environmental rights is concerned can be placed in proper context. So the mandate of the African Court, as per the protocol that establishes it, is quite broad. And it obviously extends to the protection of environmental rights, because the right to a satisfactory environment is clearly embedded within the African Charter on Human and People's Rights, which is the primary instrument that the African Court applies. So the court's role in safeguarding environmental rights flows directly from its primary protective mandate. And the court serves as the judicial forum that ensures accountability for environmental rights and tries to deliver just outcomes in matters concerning the environment. In the fulfillment of this role, the court can hear cases alleging violations of all rights within the African Charter, but it also has a jurisdiction to render advisory opinions. So there is the contentious jurisdiction and then the advisory jurisdiction of the court. In the advisory jurisdiction, the court provides authoritative opinions on questions of law that have been placed before it, including questions relating to environmental rights. Like many other regional courts, the court also has a jurisdiction to order provisional measures, and this is particularly relevant in environmental cases because this can be used to stem or to stop further violations pending the ultimate disposal of the matter before the court. And if the court finds violations, the protocol in Article 27 mandates it to order reparations. And unlike other regional human rights systems in Article 27.2, the court is given a very broad latitude to order appropriate remedies, which it has interpreted to cover restitution, compensation, damages, rehabilitation, and measures of satisfaction. So there is an express mandate within the protocol to order to grant the court very wide latitude in terms of what reparations can be ordered. The decisions of the court under the protocol are binding, essentially meaning that state parties are under a duty to implement them, and we don't have an appellate chamber. So decisions of the court are final and binding, and the parties are under an obligation to implement them. Insofar as the jurisdiction of the court is concerned, I would like to highlight the fact that the jurisdiction of the African Court is also unique because of its breadth. The court has jurisdiction over all cases and disputes concerning the interpretation and application of the African Charter. But the protocol goes on to say that the court's jurisdiction extends to any other relevant human rights instruments ratified by the state concerned. Now, this means that in practice, the court has jurisdiction to pronounce itself on the African Charter, but also on any other human rights instrument that has been ratified by the state that is before it. So in the fulfillment of this part of its jurisdiction, the court has interpreted or adopted interpretations of instruments adopted even within the UN system, as long as those instruments have been ratified by that particular state concerned. So how has this in practice manifested itself insofar as the right to a satisfactory environment is concerned? I think given the constraints of time, let me refer simply to the decision of the court in Ligue Ivorienne de Droits de l'Homme and others against the Republic Cote d'Ivoire, which is a decision that some of delegates here might be familiar with. So in this matter, the genesis was that a cargo ship had offloaded toxic waste in Abidjan. And as a result of that, the allegation was that people within Abidjan and the other areas in which they had attempted to dispose of the waste had suffered violations of their right to health, the right to an environment, and that generally there was toxicity brought into Abidjan as a result of the dumping of the toxic waste. So the court in this matter applied the African Charter, but also applied the OHCHR's Convention on the Conservation of Nature and Natural Resources and other instruments that were pertinent to the resolution of the question within the African context. But the ultimate result is that the court vindicates its role to protect the environment as manifested in the Charter, also in the OHCHR's Convention and other applicable instruments. What you will note, though, is that the court has taken a very broad view to standing before it, meaning that, and this is very relevant for environmental rights, meaning that insofar as the commencement of action before it is concerned, this is not limited to direct victims. So it's not just the persons directly affected by the particular infringement that can come to court to trigger its jurisdiction. So this allows for public interest litigation. So we have very permissive rules on standing, meaning that action can be commenced on behalf of individuals affected, not only by themselves, but by people acting on their behalf. This also has implications for environmental rights because the corporations cannot be sued directly before the court. But as was demonstrated in the case against Cote d'Ivoire, states can be sued and found liable for failing to regulate the actions of corporations, especially multinational corporations. So that, I think, has been part of an innovative approach on the part of the court. In terms of challenges, I would harken back to what I mentioned yesterday. One of the biggest challenges is, of course, non-compliance with the decisions of the court. There's also the question of limited access, because only few African Union members have made the declaration permitting individual and non-governmental access to the court. Other than that, I would say the court remains committed, both practically, but also because of the instruments underlying its establishment, to contribute to the strengthening of the protection of environmental rights in Africa. Thank you so much.
Thank you very much, Dr. Muisa, for sharing the experience from the African Court. And one of the processes that a lot of us will be looking forward to participate and support and learn from, of course, is the pending advisory opinion, of course, on climate change that is now under the African Court on Human Rights, and I think that and people's rights. And one of the key aspects mentioning from the case that you shared, it's the possibility for the African Court to address and contribute to the world to understand both the individual but also the collective aspect of the right to healthy environment as different as other human rights mechanisms in the world. The African Court and the African Charter talks about both individual and collective rights, which is a very amazing and exciting aspect also that we look forward to be seeing how to develop. And with this, I'm pleased also to give the floor now to Ms. Zoe Rhinestone-Cross, that we heard also from yesterday. She's the Deputy Head of the President's Office from the European Court of Human Rights. And she has been the Deputy Head since 2024. And I'm pleased to give you the floor also to hear from the European Court of Human Rights.
Thank you so much. It's a pleasure to speak again in a panel today after our interesting discussions on this topic yesterday. and it gives me a chance to expand a bit on the work of the European Court of Human Rights, because as we heard yesterday, the Council of Europe has a number of conventions and instruments which are dedicated to protection of the environment. The court is not one of them. The European Convention does not explicitly contain the right to a clean and quiet environment. In fact, none of the articles under the convention speak of such matters. But Director Benitez dwelt on the work of the court yesterday, I think because in practice, the court's case law and the cases that it has decided show that it has contributed very much so to the regional protection of the environment and provided remedies for environmental harms. So we'll look first a bit about the protections that the convention has afforded to applicants in that context, and then talk about some of the challenges that are faced. So over the years, the court has been seized by applicants which have asked it many questions in litigation about environmental risks and harm. So we have around 300 judgments and decisions on this topic, which date back many decades. So if we go back to the 90s, for example, we have cases like Guerra and others against Italy, where the court found that the authorities had failed in positive obligation to protect the applicants from malfunction at a chemical factory. Staying in the late 90s, Brincat and Malta, which I mentioned yesterday, where the court found that the respondent state had a responsibility, which it had failed to meet, to protect the applicants from exposure to asbestos working in the Maltese shipyards. And I open a small parenthesis here, because when we talked about this case, we talked about causation. And so I went back to the judgment to have a little look yesterday. And indeed, the court explains that the Maltese government should have known from the early 70s, given the scientific consensus, that asbestos was an important source of environmental harm and a pollutant, and therefore it had an obligation to protect the individuals. So I just close that little parenthesis on Brincat there and move on to judgments where the courts looked at, for example, impacts of urban development. So construction of motorways, railways, that kind of thing. Hatton and others against the United Kingdom, again, a decision from the late 90s was about the expansion of the Heathrow Airport in London, and individuals wished to bring complaints about noise and other sources of environmental harm that came from the expansion of the airport. Hatton is actually a decision about access to justice. So just to pick up on the topic that you mentioned in your introduction, because the applicants complained that they were unable in the UK to challenge the decisions of the government about how Heathrow should be expanded, and in particular whether there should be night flights. So this is environmental protection from that perspective, a bit more access to justice. We also have Kappa against Poland. This is a more recent judgment, 2021, but it's about a situation where the applicants had complained that the authorities have been building a large motorway near them and had directed all the traffic into their village for a very lengthy period of time that was causing noise and other types of environmental harm. And the court found a violation here. Staying in the 2000s, there's a case from the Grand Chamber of the Court on Yildiz against Turkey, which was a violation of Article 2 of the Convention, Right to Life, where the applicant's been living in slum conditions on top of a rubbish dump, and there's been a big buildup of methane under the rubbish dump, causing it to explode and kill members of the applicants' families. And then moving towards the more recent cases we mentioned extensively yesterday, OHCHR against others against Italy, and of course, famously, the court's climate change decision in Vereinigte Senioren against Switzerland, where it found that Switzerland failed to meet its positive obligation to protect the applicants from the effects of climate change. So this is a small survey of the hundreds of decisions that the court has given over the last decades, but they show a bit the breadth of the different types of applications that the court has been seized with, mostly under Article 2, right to life, or Article 8, right to family and private life, and how and some of them, of course, Article 6, which are about access to justice, and how the court has judged those. So this is some of the protections that the court has afforded in its decisions. And now I'll move on a bit to talk about reparations, but I think it's worth just pausing to reflect that the judgments in themselves are not a reparation, but they do provide important recognition for applicants, particularly I think ones who've been litigating for many years to try and obtain some recognition and official documentation of environmental harms that they've suffered or harms against pollution. So the judgments in themselves, they're lengthy and reasoned judgments, I would say provide a source of recognition, but they come into a system of reparation. We call it execution of the court's judgments under the European Convention of Human Rights, which applies to all the judgments where the court has found a violation. So equally to cases which concern environmental and other harms. And for every case, the question is, has the individual received the just satisfaction, the payment? Has the individual been put back in the situation they would have been had the violation not occurred? And has the state taken steps to repair the damage caused more generally and, if necessary, prevent similar violations? So these are the three broad principles that cover the whole of the approach to enforcement under the European mechanism. And I would just add that very generally speaking, this is a well-functioning mechanism. We have around 80% of judgments against states enforced. It doesn't mean that there aren't difficulties, there definitely are, but very broadly speaking, it's an enforcement system that has a large degree of commitment from the member states of the system. So going back to the Brincat case I mentioned, which to give some examples of how this has functioned, which concerned exposure to asbestos. Here, Maltese authorities created Occupational Health and Safety Authority, and they changed the law to make sure that people weren't exposed to asbestos, and also their national courts in Malta applied the European Court's reasoning, so opened up avenues for individuals to get compensation at the national level. I have in my examples here also Berdov against Russia. Russia is no longer part of our European system since it was expelled following the large-scale invasion of Ukraine. But when it was, the series of cases, several thousand applications were brought against it, which in fact concerned non-execution of domestic judgments. So access to justice issue here, but the people bringing the claims were the Chernobyl cleanup workers. They'd obtained compensation at the domestic level, but the Russian state hadn't paid out. And the court's judgments ensured that that did occur. And I'm sorry, I've gone a bit over time, but I'll say something positive about the Ona Yildiz case, where the Turkish authorities introduced regulations to govern waste management and waste storage facilities in the areas that were similar to those contested before the case. So here you see that there has been quite a lot of protection that's brought by the European Court, including the wider areas we talked about, access to justice and access to information, which are, and for which it's provided an important measure of protection, notwithstanding that, in fact, the convention itself doesn't have a specific right concerning environmental harms. But there are, of course, challenges, and I think many of these relate to the fact that the court is a court. So we see challenges like my colleagues have mentioned, and this is, by the way, from the perspective of those who are interested in vindicating and protecting their environmental rights. But of course, the court has rules and procedures, so questions of jurisdiction are important and limit the cases that can be brought, and also litigation can be lengthy. Our jurisdiction is territorial, evidently. Pollution sometimes doesn't recognize boundaries. So from the perspective of the applicants, this would be a limitation. And as I mentioned, of course, cases can take time to proceed up the domestic system. And finally, although there is overall a good recognition of enforcement, there are cases where enforcement hasn't happened or it's still rather in process. I would have mentioned Cordella and others against Italy, which is a judgment concerning the pollution caused by very large steelworks in the Taranto region in Italy, which still remains outstanding. And of course, the system's geared towards state responsibility. This isn't a problem as such, it's the way the system is. But if you're looking from a wider perspective of protection of environment, that of course limits the types of case that can be brought. Although in a similar way as my colleague explained concerning the African Charter, where there's a private actor who's caused pollution and the state hasn't regulated this, like in the Cordella case, then there could possibly be an application against the state. I do apologise, I see I've gone quite a bit over time, but we have some good examples in the European system that I thought would be interesting to mention. Thank you.
Thank you. Yeah, and talking about over 300 cases will require definitely more than 7, or 10 minutes. And thank you very much, because we have heard some examples. It's a little bit of the tip of the iceberg of the cases that these courts have addressed, and also the importance of litigation and the actors that bring these cases, even if it's an exception and subsidiary, of course, bodies, but the fact that people and communities and victims litigate these cases in national jurisdictions and then go to regional cases also. First of all, it's the exercising of access to justice, but also provides, as we heard, the possibility for states that to first identify the cases where some violations have happened, and also provide the remedies, even if they're imperfect. And hopefully states and the courts can understand from these situations and, as I say, pollinate knowledge with each other, and are able to, and hopefully we're able to prevent the repetition of these situations. As the asbestos case, for example, I would say that didn't only impacted Europe, but also elsewhere. And we have heard also similar situations. I mean, definitely freeways or infrastructure projects, if we heard already from the cases in Africa and Europe, are causing this litigation. And with this, in thinking also mentioning situations where states are not regulating or controlling adequate in an adequate way to private actors, we want to hear also from Ms. Milagros Muxios, from the legal advisor in the Office of the President from the Inter-American Court of Human Rights. She's a Peruvian lawyer and, as I mentioned, legal advisor and chief of staff to the presidency of the Inter-American Court on Human Rights. And so the floor is yours. Thank you.
Thank you very much. Buenos días. So yesterday I already explained a little bit about the jurisprudence of the Inter-American Court of Human Rights on environmental matters. And today, under this panel, I would like to explain a little bit about reparations. So next slide, please. So I will divide my presentation into 2 sections. First, trying to provide a framework of reparations within the Inter-American Court, and then explain a little bit about a case that was already mentioned yesterday, which is La Roya against Peru, and a couple of reparations that were developed by the court. So first is a general framework of reparations. So one of the central pillars of Inter-American Court jurisprudence is its doctrine of reparations. And since its early judgments, the court has affirmed that reparations are the indispensable bridge between the declaration of a violation and the effective restoration of rights. They're not symbolic gestures, but concrete binding obligations designed to redress harm and prevent repetition. So in the court's reparation practice is not about comprehensive, and we have several examples of it. We can have restitutions, compensations, rehabilitations, satisfactory measures, warranties of not repetition. So each judgment typically orders several measures tailored to the circumstances of the case and the needs of the victims. This has made the monitoring of compliance with reparations one of the most demanding activities of the court. And in this framework of its compliance monitoring function, the Inter-American Court has not limited its work to its seat in San Jose. Next slide, please. It has also held hearings and procedures directly in the territory of responsible states between 2015 and 2024 The court has carried out such activities in Honduras, Mexico, El Salvador, Panama, Guatemala, Costa Rica, Colombia, Brazil, Paraguay, Chile, Argentina, and Uruguay. So by the end of 2024, the court was supervising compliance in 322 cases involving not fewer than 1,755 measures of reparation. So monitoring, it's a difficult work at Inter-American Court because we share a volume and complexity of reparation ranging from monetary compensations to structural reforms that illustrate the court's holistic understanding of justice. So a case is only closed once all reparations ordered have been fully complied within the case. Next slide, please. And now we'll describe a little bit of what happened in La Roya against Peru, which is an example of how this holistic view takes one particular importance in a case involving environmental harm. So the case arose from the situation in the city of La Roya, located in the Peruvian Andes, where decades of metallurgical activities caused severe contamination of the air, water, soil, and scientific studies show extremely high levels of lead, arsenic, and cadmium in the environment, directly affecting the health of its residents. So more than 80 people were identified as victims whose rights to life, personal integrity, health, and healthy environment have been violated. So the court declared the international responsibility of the state of Peru and ordered a series of reparations, to which I would like to describe briefly. So the first one of these reparations is for the Peruvian state to develop an environmental compensation plan. And this means that, unlike the compensatory measures usually seen in the Peruvian environmental regulation, when compensation is tied to a project-specific environmental impact assessment, the court required something far more ambitious, which is a comprehensive ecosystem-wide program of restoration. And it obliged Peru to have a zero net loss of biodiversity in the area that was contaminated, to have an ecological equivalence. That means compensation must not be generated but equivalent to the damage suffered, but it needs to go beyond that, and create additionality. So the plan must create ecological gains beyond mere replacement of the ecosystem that was harmed. So to comply with this, Peru must design a multi-sectoral plan involving environmental, mining, health, and local authorities. It must include update baselines, measurable target, long-term financing. So it's a complex structural modification that needs to be taken in place. Next slide, please. And a second reparation, which is a structural reform of the industrial regulation that Peru has. So the court also ordered Peru to ensure that all mining and metallurgical operations comply with international standards, namely the UN Guiding Principle on Business and Human Rights and the Framework Principles on Human Rights and the Environment. So this was not the first time that the court addressed the link between business activities and human rights. There is another case, and it's named Buzos Misquitos against Honduras, where the court had already examined the obligation of the states in contexts where private actors engage in extractive or resource-related activities that endanger human rights. However, in La Roya, the court went further and made 2 points explicitly. First, that mining and metallurgical companies have a direct duty with respect to human rights. The holders of mining concessions must conduct their activities in full respect of the right to life, health, and healthy environment. And the second obligation is that the state has a preventive obligation to regulate, supervise, and monitor extractive operations. So it's not enough to sanction violations after they occur. The state must establish a robust regulation framework, conduct oversight, and ensure continuous enforcement. So according to this obligation, it requires Peru to reform its environmental licensing system, to apply the polluter pays principle, to strengthen accountability mechanisms to hold corporations responsible, and it creates a condition for the approval of mining projects. So Buzos mosquitoes, which is the case that I explained a little bit, opened that door to the discussion of cooperation duties. And La Oroya consolidated that clean dual obligation of that companies must respect human rights in their operation, but a state also needs to regulate and enforce this duty effectively. However, it is important to stress that compliance remains limited. So in the La Oroya versus against Peru has 19 reparation measures, and till February of this year, Peru has only fulfilled one of the reparations ordered by the court, which is the publication and dissemination of the judgment and its official summary. But again, this case was notified in 2023. We still have a long process to come through. And the court is aware that in this particular case, many challenges will be faced, but of course, the court works hand in hand with countries to make feasible to comply with these reparations and will develop its monetary compliance dutifully. So Peru and other countries can also repair all the guarantees that they have violated to begin with. So the most substantive environmental measure, which is such as the design and implementation of the compensation plan and the structural reform to regulate extractive activities, it remains pending. And it underscores both the complexity of the obligations imposed and the need to continue with international monitoring to ensure effective implementation. Muchas gracias.
Muchas gracias, Milagros. Thank you very much. And it's very interesting to hear this. I actually dare to share a little bit the first picture that you saw, a man with a girl. Her name is Amparito. She was probably 3 when the case started, the litigation started. And today she's an adult, of course, because the case was her. Thank you. She is today a therapist for respiratory illnesses, both in La Oroya and Lima. And so it just, to me, is an example of how much victims are actors of change, and these cases are a piece of their lives. But it also reflects in the importance of access to justice in so many ways. And of course, the litigation and the court doesn't mention anything about that. But today, she's helping a lot of people in their to deal with their respiratory illnesses. Thank you very much, Milagros. And now we would like to hear also from Mr. Osmani Diallo, Director of Research and Documentation from ECOWAS Court of Justice. Mr. Diallo is Director of Research and Documentation at the ECOWAS Court of Justice, and he oversees legal research, case documentation, and development of jurisprudence resources that support the court's mandates for ensuring justice and upholding human rights across West Africa. Thank you.
Thank you, Madam Chair. Distinguished delegates, ladies and gentlemen, good morning. Once more, it is a pleasure to be part of this workshop, and the ECOWAS Court of Justice is grateful for the opportunity. So quickly, I will share with you the perspective of the court with regard to holding, let's say, for upholding accountability and also provide the remedies for environmental degradation and ensuring the protection of a clean, healthy, and sustainable environment. So the ECOWAS Court of Justice does that first by interpreting the text, and the main text we apply in human rights, because this is within the general human rights mandate of the court. So we apply the African Charter on Human and People's Rights, and as you all know, Article 24 of that document refers to the protection of the environment. And ECOWAS has also other policy documents like the regional ECOWAS Regional Climate Strategy 2022-2030, and which has detailed measures to be taken by member states and also institutions of the community in order to ensure the protection of the environment. In 2020, the ECOWAS also enacted a directive for member states concerning a component of the fuel that is being used within the community, because there is also much pollution coming out from that, and that was a concern for the community. But as you can see, this is the really legal framework which need to be strengthened and enhanced. The jurisprudence of the court, I should say that it is an emerging jurisprudence. The court has not had any opportunity to deal with cases concerning climate change, but at least the court had the opportunity to deal with 3 cases concerning pollution. The first case is the Sept case in 2012, Sept versus Nigeria, and it concerned the spillover fuel in the whole region of the Niger Delta of Nigeria, which affected the means of livelihood of the communities living there. And the case was brought before the ECOWAS court, and the ECOWAS court admitted the case, and also looked and found that effectively the right to a healthy and satisfactory environment had been violated. And what is very important in that case is that the court ordered measures which are all, directed at 1, the restoration of the environment, the restoration of the livelihood of the communities. This is 1. And 2, the prevention of future occurrences. And the 3rd, the need for the member state, so Nigeria, to ensure that, the companies that are involved, first of all, to make sure that there is regulations that can govern the behavior of these mining companies, and also that companies that are not following the regulations can be brought to justice. So those were actually the 3 remedies. The court didn't award compensatory, amount to the communities, although there was a demand and so on that, but the court found it maybe difficult also for a whole region, about 4 to 5 states of Nigeria, maybe to the distribution of those compensation, and the court found it enough if the environment is restored and future occurrences prevented. And there is also a case concerning Senegal that was the Ligue Sénégalaise des droits de l'homme versus Republic of Senegal, which concerned really the toxicity of the fuel that is being consumed in the country and more broadly in the sub-region. Unfortunately, that case didn't go through, and it was disposed of at the admissibility phase. And unfortunately, that was because of a relief sought by the NGO, Ligue Sénégalaise des droits de l'homme, which went beyond what was, admitted by the court in public interest litigation, because we do a lot of public interest litigation. But one of the conditions is that the applicant shouldn't pursue personal interest and shouldn't ask for remedies for its own personal interest. So this is one of the conditions, and because of that, the Ligue Sénégalaise des droits de l'homme requested for 50 million as compensation for itself. I think that the debate is still ongoing, and it is possible that maybe the court have second look into that, because the court could have ruled in the rights and obligations involved, but dismiss that application for compensation. But because of that, the court decided that the case was inadmissible because it was under the public interest litigation, and yes, the substantive issues were not addressed. So again, the challenges, they are known. We know that there is a problem of resources when it comes to common goods, where you don't have NGOs, powerful NGOs that can take care of the common goods. Sometimes application will not come to the court. And people may also be unaware of their own rights, and they may also lack resources. So there is need really to find a way of supporting peoples and communities that are affected so that they can bring cases. And that can be done through partnership. And yes, the opportunities for cooperation, I think there is need for regional synergy, establishing a working group linking the Office of the High Commissioner, UNEP, UNDP, regional human rights mechanism, and also national human rights institutions, knowledge sharing, because this is also an area that is very technical. So there is need to build the capacities of judges and the lawyers working in support of those judges, and support also state in national implementation. And finally, to conclude, I will conclude by a question, because in our own experience at the ECOWAS Court, we have noticed that the human rights system is state-centered. So it is only states that can be respondent before the ECOWAS Court of Justice. What we have noticed is that when it comes to this environmental degradation and damages, sometimes it is powerful companies, multinationals, mining companies that are really behind it. So we were just asking whether maybe it would not be possible to think about having those companies sued before the international mechanism, but not alone, but along with the state. Because if they are present, they can also defend themselves, and maybe it will be possible to have also some measures that will be, some action to be ordered directly to those companies. And this also, to finish very quickly, will prevent the situation where we know that some of those countries, developing countries, they don't have enough means really to hold those companies responsible. And when they try to do so, it is either a problem that is bilateral between the host country and the home country of the company, of the mining company. This is one. And the two, also, there is other framework, international framework, that promote, for example, free trade. And there are issues, and I think that we need maybe to start thinking about those issues and how to best address them. Thank you very much.
Thank you very much for this very interesting presentation, Mr. Diallo. Sharing not only the experience from ECOWAS on very key cases, and one of these in Nigeria. I wanted to share also that it's, of course, this case was key, and the situation has been so complicated that the same facts and spill and contamination has also evolved in litigation in the UK and other places. So when talking about accountability, and this linking to the last question, an amazing element that you brought is how to actually have accountability when there is not only the state that is responsible and perpetrators, but also private actors. And this was part of the questions, and is one of the challenges that we have seen not only in human rights mechanisms, but also, as I mentioned yesterday, and I wanted to bring it today, the challenges that states now are facing when even complying with national laws and international laws and undertaking environmental impact assessment, and sometimes for the process or denying permits, then they are subject to international arbitrations, as you mentioned, the international trade, which is, we will have time to talk a little bit about this after we hear, of course, from Ms. Anjali Balathingam from the Human Rights who is a human rights officer from the OHCHR, the office petition section. And she has worked there for 12 years, mainly with the petition section on complaints before human rights treaty bodies. And she's an attorney, previously practiced law in the US as member of the bars in both New York and California. Thank you very much. The floor is yours.
Thank you very much. It's a pleasure to be with you and to be in such distinguished company to share with you the ways in which the UN human rights treaty bodies have assessed complaints submitted by individuals on environmental issues. And you may already be familiar with the 10 UN human rights treaty bodies, which include the Human Rights Committee, the Committee Against Torture, and many others. And you may also know that 8 of these treaty bodies are currently able to examine complaints that are submitted by individuals. And the petition section assists those 8 treaty bodies in processing the complaints with a stance of impartiality and equidistance with relationship to parties. There are currently more than 1,500 complaints that are registered and waiting to be examined by the treaty bodies. And in a typical year, the treaty bodies collectively examine more than 200 cases. I'm here just to touch on a small fraction of those overall cases, those which lie at the intersection between human rights and the environment. Thus far, most of this jurisprudence has come from the Human Rights Committee. It's not a large body of jurisprudence at this stage. It's germinating rather gradually, but the committee has set some standards in relation to human rights, the environment, and business activities, use of natural resources, non-refoulement, climate change adaptation, and climate change mitigation measures. So let me just give you a quick overview. So several decades ago already, the Human Rights Committee began exploring this connection between human rights and the environment. In 1982, in EHP versus Canada, the committee noted that a complaint concerning the storage of radioactive waste had health effects and raised serious issues with respect to the right to life. It nevertheless found the case inadmissible because the complainants had not exhausted domestic remedies, which is one of the preliminary requirements for submitting a complaint. More recently, the committee has more concretely addressed the impact of business activities on the environment and human rights. In the case of Portillo Cáceres and others versus Paraguay, which was decided in 2019, a private company had sprayed toxic agrochemicals on crops, and this had damaged the health of local tenant farmers in the land upon which they depended. It contaminated water supplies. The committee considered that with respect to the state, the heavy spraying of chemicals in the area posed a reasonably foreseeable threat to life, and that the state had not adequately enforced environmental regulations. So the committee found several violations, including of the right to life and freedom from arbitrary interference with privacy, the family, and the home. In 1995, so going back in time a bit, the committee addressed claims involving legislation affecting the ability of Maori to engage in fishing, one of their traditional livelihoods. The committee found certain claims in that case admissible, notably in relation to access, the right of access to the courts to determine environmental rights, and the right to enjoy one's own culture. However, the committee found no violation on the merits, but in relation to cultural rights, it did find that there existed personal, tribal, genealogical, and spiritual connections between the Maori, the fish, and their fishing grounds, and it therefore observed that damage to the environment or to the fisheries could be felt by a Maori person or tribe. Now, turning specifically to climate change, the Human Rights Committee has noted that climate change is a potential driver of migration. 6 years ago in Te Tirta versus New Zealand, the committee decided the first international climate change refugee case, which was brought by a national of Kiribati who had sought asylum because of sea level rise, storm surge, and other adverse climate impacts. The committee found that the deportation of the complainant to Kiribati, which had occurred in 2015, had not violated his right to life, but it opened the door to future refugee claims in relation to climate impacts, including slow onset effects. And it stated that without robust national and international efforts, the effects of climate change could violate the rights to life and the right to freedom from ill treatment, thereby triggering sending states' no-refoulement obligations. The Climate Committee has also found that inadequate climate adaptation measures violated the rights of Indigenous peoples in 2 cases. For example, in 2022, in the case of Billy and others versus Australia, the committee requested remedies for Indigenous Torres Strait Islanders. The committee found that coastal erosion in those low-lying islands and the flooding of the complainants' homes had violated their rights to freedom from arbitrary interference with privacy, the family, and the home, and had also violated their cultural rights, taking into account their interdependence on the health of their surrounding ecosystems, which were located in traditional Indigenous lands. Now, as for greenhouse gas emissions and mitigation measures, the Committee on the Rights of the Child has decided, in effect, that the Convention on the Rights of the Child may give rise to extraterritorial obligations to address climate change and combat climate change. In 2021, it examined carbon emissions cases that had been brought by 16 children against 5 states, Argentina, Brazil, France, Germany, and Turkey. And the committee concluded that the complainants had not exhausted domestic remedies, but it found that the 5 states had effective control over the sources of the emissions that had reasonably contributed to causing foreseeable harm to the health of the children outside their territories. So this is a very short summary in the limited amount of time that we have of some of the key findings of the UN Human Rights Treaty bodies on the nexus between human rights, environment, and climate systems. Regarding challenges in the system, I would echo the challenges that have already been noted by the other panelists. There is perhaps limited awareness and limited understanding of the mechanisms of the treaties and limited ratification of some of the instruments as well, some of the complaint procedures, resource constraints, of course, affect both the Secretariat and the parties. There's also the issue of the multiplicity of the treaty bodies, which means that parties need to be familiar with different treaties, with different general comments issued by those different committees, and with different rules of procedure for each and different jurisprudence for each committee. The treaty bodies also have word limits on their decisions, which means that they're not able to enter into very extensive technical discussions of legal and technical issues. So those are just some of the challenges that we face. Regarding remedies, often the treaty bodies leave a little more discretion on the courts to the states to determine what constitutes effective remedies. They also take into account the requests of the authors. Usually the committees request adequate compensation and non-repetition of the violation. In Portillo Cáceres and others versus Paraguay, the case involving toxic agrochemicals, the committee requested Paraguay to undertake an effective, thorough investigation into the events in question, which had led to the death of one of the tenant farmers and damaged the health of others. It also requested that the state impose criminal and administrative penalties on the parties responsible for the events, and it requested full reparation, including adequate compensation to the authors. In Billy and others versus Australia, which is the Torres Strait Islanders case, the committee asked Australia to provide adequate compensation, consult with the Torres Strait Islanders about their needs, and continue climate adaptation measures. Thank you very much.
Thank you very much, and thank you all the panelists for your amazing presentations. And we already have heard not only from a very variety of cases in different jurisdictions, but also linking to several elements of the right to healthy environment and other human rights directly linked, including cases in relation with infrastructure, toxic waste, pesticides, air pollution, climate as well, and of course including the impacts from fossil fuels spills and the responsibility of multinational companies. And with, of course, throughout the cases, we heard the importance of access to justice and the challenges as well. I want to also highlight and remember, because one of the objectives of not only this panel, but the workshop that we're being part of yesterday and today is what is that we can do to coordinate better and collaborate. So this suggestion to bring together a working group or maybe a platform, we heard yesterday from my colleague Siobhan from Special Rapporteur on the platform that exists already to address issues on refugees, migration, and trafficking. And so maybe putting together a platform to share information or community of practice can be something that we create from this. The other element that I want to highlight, because it also links to the conversations yesterday, is the importance of science. In all of these litigations, of course, the courts didn't decide themselves, and the treaty bodies, they used a lot of science behind, and that's one of the key important elements included. So with this, I would like to open the floor to questions and comments, both from the audience and the panelists, and we still have 25 minutes. So are there any comments or questions? Yes.
صباح الخير للجميع. نشكر كافة المتحدثين على ما طرحوه من أوراق عمل وقضايا واقعية تناولتها المحاكم المختلفة في الدول الأوروبية والأفريقية والأمريكية. أولاً أعرف عن نفسي محمد الشحي، رئيس لجنة الميثاق العربي حقوق الإنسان في جامعة الدول العربية. لدي سؤال موجه إلى سعادة المستشار نكاتا فيما يتعلق باختصاص المحكمة الأفريقية لحقوق الإنسان والشعوب في النظر وفي شكاوى الأفراد، حيث أن البروتوكول المنشئ للمحكمة يتطلب أن تكون الدولة الطرف صدقت عليه وسمحت لتلقي الشكاوى الفردية. من وجهة نظر إلى أي مدى يحد هذا التحفظ إلى تحقيق الإنصاف خاصة في قضايا البيئة، وهل هناك بدائل للأفراد فيما يتعلق بمسألة الإنصاف، وهل هناك ثمة محاولات تجعل الدول المتحفظة على هذا الإجراء تسحب مثل هذه التحفظات؟ شكرا.
Thank you. Do we have another question? Maybe we can take 2 or 3 and then start with the answer. Yes, please go ahead.
I have a question about species protection. It's been really interesting to hear about these cases, but I wonder how often do you use an argument that there needs to be a preservation of habitat in order to be able to protect the environment? Thank you.
Thank you. And we had another question. Please go ahead.
Good morning. First of all, also my thanks to all the panelists, which for me has been a very enlightening discussion. I'm not a legal scholar, so I apologize if my question is a bit out of place. What I just observed is that global value chains are increasingly more global, and we have impacts in different countries. I believe examples were mentioned of mining. We might have effects of recycling in another part of the world of the same products. And I believe you, Madam Special Rapporteur, mentioned it. How can we increase the exchange of information? Because we see different courts doing relevant work on the different topics. But we obviously here also facing what have to deal with global structures of global businesses which have subsidiaries in various parts of the world. How can we ensure the proper flow of information so that the rights of victims can be upheld? Thank you.
Thank you very much. So maybe we can start with Mr. Wisa on the question of the African footprint.
So in terms of access to the court, what the protocol says is that the court can hear cases commenced by individuals or non-governmental organizations. It can also hear cases commenced by state against another state. I think, if I understood your question correctly, it relates more to individual and non-governmental access to the court. So the structure of the court is that states sign the protocol but they have to then make a separate declaration under Article 34.6 to grant individuals and non-governmental organizations direct access. Now, if you ask me, my personal preference would have been that the access to the court should just be open without the declaration, which would have been ideal, because then the court would have been open to everyone across the continent to access it. But the history behind that, which is not also unique to the African court, is that this was one of the compromises during the negotiation of the protocol establishing the court. As history has it, there were challenges in getting all states to agree to the operationalization, establishment of the court at the time the protocol was being adopted in 1998. And one of the compromises that was made to get the protocol to be adopted at that point was that individual access would be regulated by states having to make the extra declaration to permit individuals and non-governmental organizations to commence cases directly before it. The result, as I mentioned in my earlier presentation, is that access to the court is a bit limited in practice. And I think this relates to your second concern. Since the court was established, I think only, at the moment, I think only 8 states permit direct access. And that is partly because some of the states that made the declaration have subsequently withdrawn that declaration. I think the first was Rwanda. Rwanda withdrew its declaration to grant individual access. The host country itself, Tanzania, withdrew its declaration. Cote d'Ivoire, Benin also withdrew their declaration. I think the implications there are a bit obvious, but what can be, I think to the next part of your question, what can be done then? The court, for its part, has tried to engage in what we call some form of judicial diplomacy. The court has conducted sensitization visits to some of these countries to engage with the leadership about coming back, redepositing the declaration. But because of its nature as a judicial institution, there's limitations to what the court can do to try and cajole states to come back to the protocol. The other effort is left to the policy organs of the African Union to try and convince states to still deposit the declaration for those that have not deposited, and to redeposit for those that have withdrawn their declarations. So I would say individuals can commence cases. The bulk of the cases before the court have been commenced by individuals against states. Actually, since the court was established, there's been only one interstate case that has been filed, and it was only filed last year between Democratic Republic of Congo and against Rwanda. But in terms of the declaration, the reservations, as you call them, the court is limited in what it can do about that, because the decision to sign particular protocols and make reservations is ultimately political. So the court has to maintain its neutrality in how it deals with state. Thank you.
Thank you very much. And I open to the panel if anyone wants to answer the question on the preservation of habitat and species, or the one on global. Go ahead.
Thank you very much. Yes. So with regard to the question about species protection, I think we can see the environmental treaties and the human rights treaties as being complementary, but it is true that in the human rights treaties, because the focus is on the rights of humans, there is a more anthropocentric approach, whereas you may find provisions in environmental treaties requiring species protection and habitat protection. But in the committee's general comments, they have expanded a bit upon how the protection of human rights may require the protection of habitats as well. For example, in the Human Rights Committee General Comment number 36, which was issued in 2016, the committee created a positive obligation with respect to the right to life, stating that it includes the right of individuals to enjoy a life with dignity and to be free from acts or omissions that would cause their unnatural or premature death. And the obligations of state parties to respect and ensure the right to life extends to reasonably foreseeable threats and life-threatening situations that can result in the loss of life. And the committee stated that Such threats may include adverse climate change impacts and environmental degradation. Climate change and sustainable development, according to the committee, constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. So there you can see a bit of linking by the Human Rights Committee of human rights and then environmental protection, environmental degradation. Thank you.
Thank you. And do you have other comments on that, or also mentioning in relation with global value chain and the increased impact of this and how we can better exchange information and experiences?
Yes, so in terms of sharing the court's jurisprudence and information about that, the court has a knowledge, the European Court of Human Rights has a knowledge sharing website. So here you'll find guides to all our case law, including on the environment and condensed information about the court's case law, key cases to look for with all the relevant links. The court also has a superior courts network, which allows all the apex courts of its member states to exchange on developments in jurisprudence. All 46 member states have nominated their apex courts to be members of this network. And I think that the Inter-American Court has observer status for the network. So we have quite a lot online in terms of information about our case law and jurisprudence.
Thank you.
Yeah, thank you, Chair. I just want to talk about a case before us. I want to expand more, but there is a conflict between protection of habitats and rights and animal welfare. This is a case before East African Court of Justice that the United Republic of Tanzania want to expand national parks. And then they had to relocate some people, especially Maasais, who lives in those national parks, to another place. So they brought case before us. The case is pending, so I can't say more, but that's, you see how there's a conflict of rights. There is this right of their, like those Maasais who claim that they have to be protected in their natural habitat, but there is also rights for the environmental issues and animal welfare. So this how can I say this? It is still pending, so is to follow. Thank you.
Thank you. I would like to refer on the protection of the ecosystem and a little bit of context of what the Inter-American Court has done so far on that ideas. I would like to highlight the advisory opinion on climate change. I think that's quite relevant and it resonates with the question because in this advisory opinion, the court stated the protection of nature as a subject of rights. So the court noted that ecosystems are complex and interdependent system in which each component plays an essential role for the stability and continuity of the whole. And so basically, based on that understanding among other more scientific knowledge of what nature means, the court underscored that the states have a positive obligation to adopt measures to ensure the protection, restoration, and regeneration of ecosystems. So this measure must be compatible with the best available science and must also recognize the value of traditional, local, and indigenous knowledge. In addition, they must be guided by the principle of non-retrogressivity and ensure that full exercise of procedural rights. So this advisory opinion was just notified a few months ago. We don't have a contentious case against the court where nature is the subject of interest just yet. It's the first opportunity in which the Inter-American Court has referred to nature as a subject of right, and we will see how this develops further on. It's important to highlight, for example, that there is one administrative court in Colombia that the past week has used the advisory opinion of the court to support its judgment on the scope of nature. Now, this decision, again, it's an administrative tribunal, the one who used that decision, and it has been appealed by the Ministry of Environment in Colombia. I don't have the insight of this decision, but it's just an example of how domestic courts are and will be using the scope of the advisory opinion of the Inter-American Court to expand in their own the rights that they have already acknowledged in their own constitutions and domestic jurisprudence.
Thank you. And thinking about similar cases to the one that we just heard from Tanzania in the expansion of the Serengeti or national parks. It was it was also the Inter-American Court has a few cases, including in Honduras or Garipunas against Honduras and Suriname and Saramacá cases where national parks have been established without free, prior, and informed consent, and the court has addressed this. So it's also a reminder of the importance that all environmental protections, including natural parks, has to be implemented with respecting other human rights. We have a few also minutes. Is there any other? Yes, please go ahead.
Thank you. I just wanted to add something on the jurisprudence of the European Court on protection of habitats and species. We have a lot of case law concerning these issues, usually in the context of our Article 1, Protocol 1. So this is the right to property. So the cases usually arise where an individual property owner wants to use their property for some reason, and the state has imposed a limitation on that for reasons that relate to protection of nature. So there's a big variety of cases of this type, which you can find on our website, as I mentioned, but recent ones would be a ban on commercial exploitation of forests, which was a decision against Bulgaria from 2021. Or we have a Finnish case where the states imposed fishing restrictions to safeguard fish stocks, and others which are more like classic species conservation against Greece, where there were turtles on an island which were of an unusual type and required protection. So a wide range of contexts has come up amongst the whole geography of Europe on these various cases.
Thank you. Yeah, there's definitely a lot of expertise and experience in this. Are there any other questions or comments from the room and the panelists? Yes, go ahead.
And I think I will elaborate a little bit more in the next panel. But with these conservation laws and protection of species, we have also seen how these laws has been misused to also target environmental human rights defenders. So I guess the question could be is like how to reconcile the need to have these protection laws, but at the same time that these are not being misused, because that's the reality. So while we understand that this is fundamental to advance the right to healthy and sustainable environment, on the other hand, we see that issues like corruption, impunity, lack of access to justice have been also part of how defenders have been targeted. So I guess it's more to think that these environmental agreements are out there. We also need to see them with a perspective of human rights to make sure as well that are not misused. It was more like a general comment.
Thank you. Do you want to comment? Yeah, go ahead.
Thank you very much for the comment. We haven't yet seen jurisprudence relating to the targeting specifically of environmental human rights defenders in relation to climate change, for example, but there have been some human rights committee decisions on appraisals or targeting of defenders of indigenous rights, including in relation to the protection of their traditional lands. So in that case, for example, there have been allegations of arbitrary detention and cultural rights, and the committees have found violations of various rights. So maybe that's a theme that we'll see in the future of the treaty. Thank you.
Thank you, exactly. And I mean, as a rapporteur more than a chair of this panel, I want to mention that there has been several requests of communications and the mandates. I mean, I've been in the mandate for a year and a half, but even before my predecessors, there has been several letters sent to different states linking or related with either the establishment of natural protected areas or conservation or carbon setting, as we know. Like there's different environmental actions, legislations that have unfortunately have either caused, and we're hearing also from cases in Africa, but also linked directly with environmental human rights defenders, which is the topic of the next panel. So of course, we're not going to extend, but I think that is a great reminder about how these issues are interconnected and the importance also to have this in mind, and even thinking about and going further for the questions about the issues or different global sectors and companies that also might be involved in different situations. Are there any other comments or closing? We do have some time, so maybe if the panel is okay, we can close with like a minute each to like closing remarks. Thank you. And we would do it in the same order as you started, if it's okay.
Thank you, Chair. Just to say that the environmental issue is not only regional or national, it's a worldwide, and it needs the effort of everyone. And the most of challenge we have to be addressed is financial, actually, even for those litigants, NGOs to bring those cases, and also technical. That's my word of closing.
Thank you.
I think in my summation, let me just flag again, this came out, that currently pending before the court is a request for an advisory opinion on the effects of climate change. I think even though this is within the advisory jurisdiction of the court, but I think this is an opportunity that the court has been presented with to frame an authoritative statement about the obligations of states in relation to issues pertaining to climate change, and to do that from an African perspective, having focus on the instruments that have been adopted within the African Union. So this is something to look forward to in terms of clarifying the applicable law, especially in terms of obligations of states in respect of climate change. Thank you.
Thank you.
Okay, well, thank you so much. It's been very interesting. I think that probably the European Court comes with the biggest volume of cases and therefore the most information in this sense to share. But I've been very interested to hear the different perspectives on how this topic is approached in the other courts and regions. So whilst I would strongly encourage everybody to use all the materials that we make available, I think the court's very much open and interested to hearing about how we can learn more from the experience of the other regional courts. Thank you.
Thank you. And then Milagro.
Thank you. I guess just a question that I would like to refer to the last comment. There was a right to defend human rights. And so again, like the Inter-American Court in its advisory opinion also addressed this issue and noted that environmental rights defenders are at risk due to having their rights violated because of the activities they carry out. So it's interesting to see perhaps Inter-American Court doesn't have that many cases, but we do have two advisory opinions on environmental rights now and climate change that they can inform domestic courts and courts in other regions of how at least the Inter-American Court has interpreted this right within the American Convention, and it can be an important tool to use not only for state but also for NGOs and civil society to refer to how this right has been understood in the Inter-American system, and perhaps we will see different cases not next year but in the following years and see how it evolves, the understanding on climate change and the climate emergency as well.
Thank you. And Ms.
Merci beaucoup, Madame la Présidente. Je pense que je voudrais conclure en mettant l'accent, encore une fois, sur la dialectique entre le local et le global. Et encore une fois, la protection de l'environnement est intimement liée à l'exploitation des ressources sur lesquelles plusieurs États considèrent qu'ils ont un droit souverain sur leurs propres ressources. Donc, tant qu'on n'aura pas trouvé un moyen de maintenir l'équilibre entre, d'une part, l'exploitation des ressources, la capacité des États de fixer leurs propres priorités et d'exploiter leurs ressources tout en respectant en fait l'environnement, d'une part, et d'autre part, la possibilité de tenir les compagnies en fait qui sont pour la plupart du temps à la base de certaines pollutions de masse, de les tenir responsables. Je pense qu'il y aura toujours une situation d'injustice, et je le dis parce que je veux dire les pays d'où nous venons, et des fois ils nous disent voilà, vous à la cour, vous nous condamnez, mais quand par exemple nous on veut déterminer nos priorités et exploiter nos ressources, en fait, on nous empêche de le faire parce qu'on dit qu'il faut protéger l'environnement, il faut protéger les animaux. J'ai un exemple qui concerne la Gambie, par exemple, et où il y a eu beaucoup de débats autour de la question. Donc, encore une fois, pour ne pas être long, je voudrais simplement attirer l'attention sur la proposition que j'ai faite, de voir dans quelle mesure, en fait, ces compagnies pourraient aussi être avec les États quand les cas sont examinés. Parce que c'est bien beau de dire l'État doit assurer que les compagnies sont tenues responsables et tout ça. Mais je veux dire, si les compagnies sont présentes, elles-mêmes, elles ont eu l'opportunité de se défendre, cela devient beaucoup plus facile, notamment dans la pression qui pourrait résulter de l'État national de ces compagnies. Merci.
Merci beaucoup.
Thank you very much, and thank you all for your presence and your comments and questions. I just want to point out that for the treaty body system, the decisions were made by the independent members of the committees. But the system itself, of course, is created by states, and it depends on the ratification of states and their good faith compliance with the treaty provisions, and also with the recommendations of the committees and their decisions on individual complaints. So for the system to really continue, we really very much count not only on cooperation with other regional bodies, but also on the continued cooperation of states and their continued support for the procedures. Thank you.
Thank you very much. And with this, we need to close. Also, reminder how much justice needs accountability and the possibilities and the need to continue working together, either through a working group or a way in which we can continue not only reviewing the information, but also exchanging expertise. Thank you. Thank you very much. Thank you.
It's been a while. I forget.
Well, okay.
How are you? Good to see you too as well. I am gonna.
It's me?
I have a business to you, actually.
Okay, sure. Business is always good.
Okay, the colleague from the Tromsø convention would like to reach out.
Oh, super. Yeah, with pleasure. Yes. Hello, how are you? Yeah, see you again.
Yeah.
Hi, Michelle. How are you? Good to see you. How are you? Hi. Good to see you again. How do I pronounce your surname perfectly? Mansevich. Okay, I should do that. Should be able to do that. Hi, Fiona. So good to have you here. Well, we have one panelist short, so we have more time for sharing our wisdom. So.
Oh, okay.
So good morning, colleagues. We are ready to start with the next panel. I think we have an opportunity to connect and further deepen our reflections so far. It has been a really rich morning following a very important first day. My name is Elisa Morgera. I'm the UN Special Rapporteur on Climate Change and Human Rights. And it is my absolute pleasure to chair this panel, which will focus on advancing the rights of access to information in environmental matters, the right to participate in decision-making on environmental matters, and the crucial issue of protecting environmental human rights defenders. I'll just maybe mention as an introductory reflection before going into our very distinguished and full of insights panel, the crucial importance of access to information on environmental matters. Last year, I decided to focus my second thematic report on access to information on climate change and human rights, very much focusing on the importance of connecting sources of information across all the elements of the human right to a healthy environment, to really fully understand how human well-being in all the dimensions that are protected by international human rights law is affected by climate change. But crucially, to fully understand how public authorities can be themselves best informed to perform their duties to protect human rights in the context of climate change. And it was really interesting. I received a significant amount of submissions with a lot of both indications of challenges in making that information available, accessible, including, for instance, to children, to remote communities, and of course, to make the information connected across sectors of government, across scales of governance, and ultimately for the information to empower everyone to contribute to the protection of human rights, including their own protection. Through that work, it became critical how access to information is a precondition for all of us to be able to participate meaningfully in environmental decision making, and again, how the lived experiences of those most affected by the environmental crisis we're facing are actually potentially the most important source of information for public authorities at all levels to truly understand the challenges ahead, truly zoom in on root causes, and being able to take effective action to protect our human rights in the context of environmental challenges. And that leads us to the third part of our panel, which is the paradox of how environmental human rights defenders are being attacked in many different ways in all regions of the world, whereas they're not only maybe the most deeply knowledgeable human rights holders around the challenges, what is going wrong in our efforts to protect the human right to a healthy environment, but also once again to understand the full insights of lived experiences of those that find themselves at the front line of climate crisis, and who in their lived experiences are able to understand what action needs to be prioritized, what action may appear on the surface to support a just transition, for instance, but instead may still be very much entangled into problematic practices that support human activities that are very much the cause and continue to be the cause of the environment, the interlinked environmental crisis we're facing. So there is a lot to be done in terms, and a lot that we have learned through this, I think, dramatic evidence that keeps coming to the surface and being documented very carefully around the multiple types of attacks against environmental human rights defenders, but also about when we're being successful in ensuring a safe and meaningful environment for defenders to be heard, to be shaping solutions, to find justice before courts, and ultimately to fulfill their mission of protecting everyone's human right to a healthy environment. So with that, I'll invite our first speaker, Michel Forst, the UN Special Rapporteur on Environmental Defenders under the Aarhus Convention, to share with us his reflections and deep understanding about the role of the Aarhus Convention in protecting environmental human rights defenders, any good practices that have come to your attention, continuing and new challenges, and suggestions about the ways in which the UN and regional mechanisms can help to ensure their safety and their participation. Thank you, Michel.
Thank you, Elisa. Good to be again in the panel with you as chair of the panel, and happy to be with you and to share my reflections on how we could do better to protect environmental defenders. Distinguished delegates, since my election in June 22 as the UN Special Rapporteur on Environmental Defenders, together with the team, we have tried to operationalize the rapid response mechanism under the Aarhus Convention. And as you know, for those who are familiar with the convention, this is the first international mechanism safeguarding environmental defenders within what we call a legally binding instrument, a legally binding treaty. And today, I've been asked to outline how the mandate functions. Some of the key threats I've documented are achievements, and also, as you said, Elisa, opportunities for better cooperation with other mechanisms. The mandate is grounded in Article 3.8 of the Convention, which imposes a binding obligation to parties to ensure persons exercising their rights under the Convention are not penalized, persecuted, or harassed. And an environmental defender is, for the Convention, anyone exercising rights under the Convention to protect the rights to live in a clean, healthy, and sustainable environment. Individuals, organizations working on climate, biodiversity, forests, water, and impacts of industries and infrastructures. The mechanism enables rapid response, rapid action. Like other special rapporteurs, I can receive complaints and I can directly engage with public authorities across the 48 parties. I can also issue urgent appeals. I can conduct country visits. I can request immediate protection measures. Critically, the mandate has also what we call an extraterritorial reach grounded in the Convention. That is, when companies headquartered in parties operate abroad, defenders threatened by these companies from companies of those countries can seek protection from my mandate, and I can hold them accountable globally. My report on key trends will be soon available on the webpage of the mandate and will be presented at the next meeting of the parties in November. And it documents key threats against defenders across different categories and countries. Let me outline a few of them. First, what is striking is the broad issue of shrinking space. Defenders operate in increasingly restricted environment, and several parties have, as you know, adopted what we call foreign agent laws. That's the case with Georgia, Hungary, Kyrgyzstan, and Slovakia. Italy and the UK have adopted legislations targeting environmental defenders and protesters. Some authorities, like Spain and Denmark, label environmental defenders itself as terrorism. Second problem, stigmatization. Three narratives are used by politicians, private companies, and the media to delegitimize defenders: anti-development, enemies of the states, and dangerous criminals, through terms like eco-terrorists or green jihad. Third element, verbal threats and physical violence. That's the case particularly in Southern Europe, Eastern Europe, the Caucasus, and against defenders in Northern Europe. Defenders face daily threats online, including death threats, but also physical violence, beatings, break-ins, and attacks. And when companies from parties operate abroad, threats escalate to killings, kidnappings, and sexual assault on women defenders. All these threats also target their families. 4, law enforcement abuse. Excessive use of force during protests, torture in custody, arbitrary arrests, intimidating home visits, and extensive surveillance. 5, criminal justice weaponization. Retaliatory prosecutions and disproportionate sanctions are common across Europe. Defenders face prison sentences and draconian bail conditions like home detention, interdiction to protest. There's also a shift toward charging defenders with more severe charges, such as sabotage or sedition, for actions previously treated as minor offenses like traffic obstructions. 6, lawsuits, strategic lawsuits, SLAPs, common and increasing, especially in Eastern and Southern Europe and Western Europe, seeking disproportionate compensation and financial ruin. 7, additional threats include immigration-related punishments, professional sanctions affecting medical professionals, and administrative harassment of environmental organizations. 8, what we call the green transition paradox. Projects labeled green make it difficult to challenge them even when they involve irreversible impacts. And lastly, the chilling effect, which is for me a striking element in my assessment of the situation in Europe. Defenders report more and more reluctance to engage, creating climates of fear with widespread self-censorship. The mandate has achieved significant results, establishing robust and efficient working methods for the first binding treaty-based mechanism endorsed by ECOSOC, successfully intervening across multiple countries to protect defenders seeking protection, shedding light and setting standards through like my position paper and my guidelines on peaceful environmental protest on a global issue affecting democracy, repression of environmental protest, setting standards, and conducting over 20 country visits, working with defenders across the globe, including in the context of extraterritorial accountability. Enhanced cooperation for me is essential, and I would like to flag at least 2 new initiatives. The first is called the LEAD initiative. Together with defenders and NGOs, we are co-creating what we call the Leaders Network for Environmental Activists and Defenders. LEAD, bringing together defenders, governments, civil society, and UN agencies to promote a more inclusive participation of defenders and indigenous peoples to COP climate and COP biodiversity. It has been presented in New York last week during the Climate Week, and it will be officially launched in Belém with the support of Brazil and other like-minded countries. It will provide a new platform for coordination with government leaders, and Brazil's commitments to center defenders in COP30 demonstrates governmental embrace. The second element is what we call the European Regional Forum, with the support of the OHCHR Convention, OHCHR, UNEP, UNEC, the Council of Europe, and UN agencies, EU agencies. I'm trying to establish what we call a European Forum of Environmental Defenders, providing a safe space for defenders to strategize and promoting alignment of environmental policies with human rights standards. And lastly, strengthening partnerships. The mandate, since I've been elected, is trying to deepen collaboration with other UN special mandate holders, regional bodies, the SKZU agreement, and also national human rights institutions. Ladies and gentlemen, let me be clear. We are currently witnessing a global assault on those who try to defend our collective future. My report documents a chilling reality. Defenders beaten, prosecuted as terrorists for peaceful protest, their families threatened, their livelihood destroyed, 4 years prison for organizing a demonstration, 10 years maximum sentences for blocking a road, women defenders sexually assaulted near mining sites, journalists facing criminal detention, defamation for exposing pollution. This is not the work of road actors in distant places. These are patterns across parties to the Arch Convention, our own governments, our own companies, our own courts. And when we criminalize environmental defenders, we extinguish the early warning systems that protects all of us. Every silenced defender is an ignored alarm as our planet is burning. The choice before us is existential. Will we be the generation that protects polluters or the generation that protects defenders? Will we let fear silence those who speak truth, or will we have the courage to dismantle the architectures of repression we have built? My mandate will continue with independence and determination, but I cannot do this alone. Through cooperation with other human rights mechanisms, through LEAD, through the European Forum, through every diplomatic channels, we must act, not tomorrow, but now. The environmental defenders I've met do not ask for praise, they are simply asking for something more simpler, simply the right to survive for defending what sustains us. History will judge us not by our declaration, but by whether we stood with those who stand for our future. Thank you very much.
Thank you so much, Michel. And actually, I would like to take maybe this opportunity to thank you for all your work over many years, including in your previous role as UN Special Rapporteur on Human Rights Defenders, to really opening and setting this agenda. And I think your report couldn't be more timely. I think some of how you framed the issue, the severity of it, is really crucial at this time. And maybe since we have a relatively European panel, I might just take this opportunity also to reflect on the really important findings in the Inter-American Court advisory opinion on climate change around an issue that you also mentioned around the importance of intersectional protection for environmental human rights defenders, those specific threats and violence against women, for instance, but of course also indigenous defenders and others. And there's a very I think, detailed section in that advisory opinion that provides, I think, an advancement on that understanding of intersectional protection and the need for differentiated measures to ensure protection of environmental human rights defenders. I'm also wondering, since we have so much expertise in the room from different regions, if maybe at this stage already there's any comment, complementarity from other regions. A few points that caught my attention are, of course, the importance of the role of business and the regulation of business and monitoring of business in the context of attacks against environmental human rights defenders. And the point that has already been raised earlier in our conversations around extraterritorial obligations. And this is maybe an area where we can have meaningful sharing of lessons learned and concerns across regional bodies as well. And of course, something that's very core to my mandate, that green transition paradox. I mean, that might have been potentially the most heartbreaking part of my work since becoming rapporteur, and seeing not only where climate action is insufficient or we're retrogressing, but also where efforts that are on the surface at least meant to advance a transition towards a renewable-based economies are instead replicating the very same patterns of human rights violations and even more vicious attacks against environmental human rights defenders, with the even more paradoxical result of indigenous peoples, frontline communities, and others being even labeled as opposing climate action. So paradox of paradoxes. So yeah, I'm just going to have a look around the room if there's anyone who would like to have even an immediate question or a reflection from other regional realities from what Michelle has just shared, just to make the panel more interactive maybe. But if you need more time to reflect, then we'll continue otherwise. Okay, so in that case, I'm also very pleased to share the panel with our very good colleague and long-standing, I think, champion of the right to a healthy environment, and also environmental human rights defenders, Ms. Fiona Marshall, who's legal officer and secretary to the Aarhus Convention Compliance Committee. We have already heard yesterday from Astrid, the UN Special Rapporteur on the human right to a healthy environment, about how much we can learn and how much the Aarhus Convention Secretariat and the Compliance Committee are sharing with UN special procedures on what's being learned about, for instance, environmental impact assessments, and around that access to information and participation in environmental decision making. And today, Fiona will share her insights over so many years of tireless work on the main challenges and obstacles in the protection of the rights of access to information and participation in environmental matters, but also good practices that may have been shared in legislation, public policies and programs that ensure the participation of human rights holders, and maybe ideas either of existing or potential forms of cooperation among regional mechanisms. So Fiona, the floor is yours. Thank you so much.
Thank you very much, Alyssa. And thank you for inviting me to participate in this important workshop and to follow up on the eloquent words of Michelle Force, the Special Rapporteur on Environmental Defenders under the Aarhus Convention. I actually would like to share with you today some insights from the perspective of the Compliance Committee of the Aarhus Convention, which is another mechanism under the Convention. And in my presentation, I will address three aspects: 10 features of the Compliance Committee that may be of interest to other human rights mechanisms, challenges that we see increasingly faced both by the Compliance Committee and by those who engage with it, and to close on a more hopeful note, some opportunities for collaboration and exchange with other human rights mechanisms. First, I would like to begin with a very short introduction to the Aarhus Convention Compliance Committee. After the Aarhus Convention's entry into force in 2001, the Compliance Committee was established by the meeting of the parties at its first session in October 2002. The Compliance Committee receives cases regarding any provision of the Convention, including access to information, public participation, access to justice, and the protection of persons seeking to exercise their rights under the Convention, environmental defenders. After developing its working methods, the committee received its first cases in late 2004 and adopted its first findings in February 2005. The committee has therefore been assisting parties to be in compliance with the Convention for more than 2 decades now. During that time, it has continued to develop its working methods to try to make them more effective, more efficient, while always upholding transparency and participation. And it is those features, or at least some of those features, that I would like to focus on today. So to this end, I would like to share with you 10 rather innovative features of the Compliance Committee that might be of interest to other human rights mechanisms. First, 1, committee members can be nominated to the committee by a party to the convention, by a signatory, or by NGOs promoting environmental protection. 2, members serve in their personal capacity, and an established practice is that no member should work for the executive branch of the government. Upon taking up their role, committee members must always sign a declaration of independence and impartiality. Thirdly, and very, very importantly, any member of the public can submit a communication to the committee, either on their behalf or on behalf of someone else. Similarly, and this is the fourth point, any person or NGO can submit information and statements to the committee as an observer in any pending case or follow-up procedure before the committee. Interestingly, all documents received by the committee or sent by the committee are posted on the committee's website. So we're subject to the redaction of personal data and any information that might put anybody at risk of persecution or harassment. Every document that the committee deals with is posted on its website under a particular case. 6, except where the facts and legal issues are very clear, the committee will hold a hearing with the party concerned and the communicants and observers prior to it commencing its deliberations on its findings in a case. 7, before it completes its findings, the draft findings and recommendations are sent to the party concerned, the communicant and observers for any comments that they might have. And finally, when it finishes and adopts its findings, the findings are submitted to the meeting of the parties for their endorsement, which gives the findings great weight under international law. And in the 2 decades since the committee has been adopting findings, in all findings except one, those findings have been endorsed by consensus, and on one occasion they were endorsed through a vote. Next, I would like to turn to the follow-up procedure of the committee. This is my 9th point, and I think that this could be quite interesting for some other human rights mechanisms. So over the past decade, the committee has developed a very interactive and participatory procedure to follow up on parties' non-compliance. Following the endorsement by the meeting of the parties of its findings in a case of non-compliance, the meeting of the parties will adopt a decision about that party's non-compliance, which then the committee will review progress to implement on during the next institutional period. That will begin with the party concerned being required to submit a plan of action. Then each year it must do a progress report to show the committee how it has progressed. When the plan of action and the progress reports are received, they are sent promptly by the committee to the communicants and observers for their comments. Then the committee examines the plan of action or the progress report together with the information received before it sends its own review back to the party concerned and the communicants and observers. Finally, at the end of the 4-year interstitial period, the committee submits its report on the progress made by the party concerned to the meeting of the parties. But before doing so, it sends its draft report again to the party concerned and the communicants and observers for any final comments. And finally, the 10th innovative feature that I thought might be interesting is something that has begun very organically, which is the advisory role of the Compliance Committee. So increasingly over the past decade, parties are proactively requesting the committee to provide them with advice on how they can implement the convention. This is in addition to the committee's existing role to review compliance. And some recent notable examples of these types of advices include the application of the Aarhus Convention in Ukraine during the war by the Russian Federation, how to carry out public hearings during a pandemic, during the time of COVID, or notifying the public of proposed projects in the transboundary context, including when there is no diplomatic relations and the other state will not cooperate. So this were the innovative features that I wanted to share with you, and I'm very happy to answer any questions that you may have about them. To close, I would like to briefly touch upon a couple of challenges that we see to support the Compliance Committee. Firstly, the challenges that the Special Rapporteur highlighted are very, very present in the work of the Compliance Committee. So we see very much the shrinking of civic space, and we see also how the push for the green transition means that parties are increasingly cutting back on their rights under the Aarhus Convention, which is making the work of the Compliance Committee ever more urgent and needed. But at the same time, resources to fund this area of work are shrinking as well. And so we see that civil society seeking to engage with the Compliance Committee are increasingly under-resourced and unable to actually effectively engage with the mechanism, because it takes a lot of work to engage effectively with the mechanism and carry on. Even if you have the right to participate, you still need to have the people in your NGO to actually be able to prepare the statements and to review all the documents. And we see that civil society is increasingly under pressure to do so. Similarly, as the workload of the Compliance Committee increases, these resources of the Secretariat who are supporting the Compliance Committee do not increase. So the workload increases exponentially, but the staffing stays the same. So those were the challenges that I wanted to face and to share. And then finally, on a hopeful note, in terms of collaboration, I wanted to share two possibilities for collaboration. Firstly, the committee meets in open session except when it's preparing its draft findings, which means that every regular meeting in Geneva of the committee, there is an opportunity for any person interested in the work of the Compliance Committee to take part and attend the meetings and see the committee working in progress, and also potentially to share their own experiences. Secondly, the chair, committee members and the secretary very often make presentations and take part in the processes of other mechanisms, primarily so far in the multilateral environmental agreement area, but it would be very nice to be able to deepen that form of engagement with other human rights mechanisms. And so I would like to end my presentation simply by saying both the chair, the committee, and the secretariat stand ready to engage with any other human rights mechanisms going forward about how we can learn from each other in the development of our procedures to better protect people who are seeking to access the mechanisms. Thank you.
Well, thank you so much, Fiona. And I think there's so much opportunity and need to compare notes on findings and approaches across regions. Well, on all the challenges you shared, and also that opportunity to learn about innovations, what is possible either because of distinguishing features of regional regimes, but also institutional innovation. So I hope that can become maybe one of the detailed recommendations we can include in the report of this of our gathering, and some of the opportunities might be there, I guess, relatively easy to grasp. I'm wondering, the sessions of the Compliance Committee, are there hybrid? Is there opportunity for?
So formally and in accordance with the rules of procedure of the Compliance Committee, absolutely you're entitled to participate remotely. Currently, the United Nations office in Geneva is not supporting hybrid meetings, which creates a challenge for the Compliance Committee to meet and to comply with its own procedures.
Thank you. That's also maybe a crucial point to note. From my part, I also noted two other ideas in terms of potential recommendations. I mean, one was going back to the point that also Michelle made, and all of us, I guess, have been contributing, which is the creation now of a European Regional Forum for Environmental Human Rights Defenders. I think under the Escazú Agreement in Latin America, there's already a structure that has been mandated by the governing organ of that regime. But of course, we have other regions here, and it'll be so interesting to hear from all of you whether you either know that if there are processes ongoing to create any form of regional dialogue and support for environmental human rights defenders, relevant organizations, or whether this is something that, again, we could put in our recommendations, including that learning where those regional forums have been established or are being established. And sometimes the startup phase is really the one where the most learning is needed, and where building on other experience can save a lot of resources and maybe missteps. The second point I also thought about is something that was already mentioned earlier on around the communications that the special procedures are preparing also in response to individuals, let's say, complaints. And while there is already some cross-fertilization, in particular, we're including in some of our communications reference to the advisory opinions, including on the Inter-American one. We have been able to include it in a few of our recent communications. I'm realizing that there could be even more cross-fertilization or support with the decisions of the compliance committee. I'm thinking also about country visit reports. There could be so much more kind of support for each other's recommendations and also follow up, as we might be called to contribute at different points in time. And I'm even thinking in terms of kind of a mapping and matching of both topics and timelines. That could be something that this potential of a platform could do, both allowing all of us to be aware of when new either compliance committee decisions, communications, but also judicial decisions are coming up and may have, regard the same country, potentially same organizations or defenders, similar topics, and then looking at timelines and where different organizations and actors could be doing follow-up and then share back with all relevant players, I guess, in this landscape. I think that there is a good opportunity there. And maybe then thinking about how we share the learning on topics that we know are recurrent. I mean, we've talked now a few times about just transition challenges, but of course, many others in terms of also the recurrent patterns of attacks against environmental human rights defenders, and just bring those more, make these more accessible, and maybe the information brought together for the purpose of those regional bodies that may have not yet engaged with those issues to the same extent, or to some of the new questions that may be arising in some of the other processes. I'll leave those ideas with you, and of course panelists are also welcome to react either immediately or in a little bit, but please do think about them and let us know what you think when we get to the questions and answers session. But I see a hand in the back. Anna Paula, jump in. Lovely to hear from you.
Yeah, just to mention, because we talked about
The mic.
Yeah, now it should be on. Yes. So we should be you just mentioned these initiatives in the regional levels on environmental human rights defenders, and in addition to this global initiative that Michelle mentioned briefly on the global level. So just to contextualize where they are. So in Latin America and the Caribbean, there is a forum for environmental human rights defenders, which is mandated by the COP of Escazú. And they were first mandated to construct a roadmap for the implementation of the article that deals with environmental human rights defenders. And now the subsequent sessions of the forum are for the implementation of this roadmap. And that, I mean, unfortunately, Chile couldn't come because they are one of the members of the core group, together with Ecuador, which I saw that was in the room, and another country that I don't. Then in Asia, we also have a similar initiative. There is an Asian Pacific Forum on Environmental Human Rights Defenders. That forum, because of the conditions of security, of safety of defenders, is closed. It's not open. But at the same time, there are regional forums on business and human rights, but there is a lot of environmental human rights defenders attending, and those tend to be more open. There was one that just took place in Asia as well about a week or 2 weeks ago. We are working with IRA, the Environmental Rights Africa Initiative, so it will be interesting to also know if colleagues that are here representing mechanisms from Africa, if you are aware of that initiative. Basically, IRA is pushing for a similar Aarhus Convention, Escazú agreement type that is targeted for Africa. So we are also working a lot in building capacities between defenders from Latin America and the Caribbean, Asia. They have already been engaged in process to build the capacity of defenders in Africa. And we are very enthusiastic of all those processes that are coming up in Africa that will engage more defenders, such as the General Command of the African Commission, the advisory opinion of the African Court. And then, of course, there is the forum that we hope that will, the first forum in Europe that we hope that will take place in the first half of next year. And then I see everybody in the panel has been involved in that initiative, so I will not spend any more time dwelling on it. It will be also interesting. We see that there is a need to have similar forums in MENA, but also in Central Asia. So perhaps that is something that could be discussed in the Q&A by representatives of these other mechanisms.
Brilliant. Thank you so much. That was really helpful. Right, and with this, I'll now pass the floor to Mr. Ulysses Quero from the International Service for Human Rights. And it would be really interesting to hear from your perspective. I was like, where is he? From your perspective and the perspective of civil society organizations, what needs to be done in order to advance the rights of access to information and participation in decision-making on environmental matters, and also protecting environmental human rights defenders? So the floor is yours.
Thank you so much, Elisa, and thank you so much for organizing this panel. It's an honor to join you today and to reflect on the rights to participation and access to information, and particularly on the protection of environmental human rights defenders. Yesterday and also today, we were talking about the progress that has been made in the implementation of the right to a clean, healthy, and sustainable environment. But most of this progress couldn't have been possible without the leadership and the vision of environmental human rights defenders, indigenous peoples, and civil society organizations. They are the ones who are actually pushing the agenda and forcing us to really go in the right direction to have these developments. From the Global Coalition for the Universal Recognition of the Human Right to a Clean, Healthy, and Sustainable Environment, or the Pacific Island Students Fighting Climate Change, the Escazú Alliance, the Alianza Escazú in Spanish, or the ERA initiative that was mentioned now by Anna, coalition and defenders are making sure that the environmental governance and environmental justice responds to the realities and the needs to protect humanity and the planet. Despite this vital role, and after more than 25 years later of the adoption of the UN Declaration of Human Rights Defenders, we see that environmental defenders continue to be one of the most targeted groups around the globe. In the most recent report by Global Witness, in the last decade, more than 2,200 defenders have been targeted. And being Latin America and Asia, the most documented cases, but this is just an indication because we know that there is a process of undocumentation, lack of documentation, of registry of attacks in other regions, like in Africa. In a similar way, the Business and Human Rights Research Center has also identified that the most dangerous sectors to exercise the right to defend rights are extractive industries, mining, oil, gas, and agribusiness. And these sectors are interlinked with the right to a clean, healthy, and sustainable environment. Negative narratives that strengthen stigma against defenders by framing them as against development, terrorists, or other terms are also helping to counter and to really make this situation for environmental defenders even worse. In the process of making sure that we get the more information from defenders, we had a series of consultations in the last years to develop a Declaration Plus 25, which is an authoritative supplement to the UN Declaration on Human Rights Defenders. Consultations happen also with environmental and indigenous peoples. And in these consultations, we saw new trends, but in fact, actually not new trends regarding the situation. This includes an increased number of enforced disappearances against land and environmental defenders, the use of new technologies, shutdowns, and surveillance, disproportionate use of force in cases related to civil disobedience that Michelle has briefly mentioned already, strategic lawsuits against public participation, adoption and misuse of laws that directly and indirectly attack and criminalize environmental human rights defenders and civil society organizations, such as I was mentioning in the previous panel, conservation laws, tax laws, foreign agents and terrorist laws and regulations, and other legislation that has been adopted
to really target defenders. And this is coupled with weak legal protection at national level, corruption, impunity, and corporate capture. The lack of sufficient funding as a whole has made also the work of defenders even more challenging. But I also want to show a positive note because there has been also some progress in the protection of environmental defenders. For example, the 2019 Human Rights Council Resolution 4011 that recognizes the vital role of environmental defenders, or regional developments such as the appointment of Special Rapporteur on Environmental Defenders, the work that has been done also under his mandate in the last years. In Latin America, there is now a vast case law to protect and recognize that the states have an obligation to protect human rights defenders. Cases like Human Rights Defender case versus Guatemala or Barahona Bray versus Chile that actually mention that defenders cannot properly defend environmental rights if they cannot exercise their own rights of access to information, freedom of expression, assembly, and peaceful association, guarantees of non-discrimination, and participation in the decision-making process. And moreover, and it has been constantly shared in these 2 days, the adoption of the Escazú Agreement in 2018 and the adoption of the Plan of Action in 2024 are already part of the binding obligations that the states have at the regional level to protect environmental defenders. This has also been confirmed by the Inter-American Court of Human Rights in the Advisory Opinion on Climate Change, in which it establishes that the Escazú Agreements and its principles is the regional standard. I also want to move on to some recommendations to really help advance the agenda to protect environmental defenders. First, we need to recognize the vital work of environmental defenders. And this means to protect the right to defend rights. This also includes financial support, close consultation, and meaningful participation in any decision-making process. 2, to consider that an attack on an environmental defender is and should be a substantive violation of the right to a clean, healthy, and sustainable environment. 3, enact and enforce laws and policies to protect the right to defend rights individually and collectively with an intersectional approach. This would include incorporating and applying the regional developments like the Escazú agreements and to revise existing legislation that could be misused against defenders. 4, introduce anti-SLAPP laws and regulations and ensure that the state and non-state actors, including businesses, respect rights and held accountable by violations and abuses that they commit. 5, encourage regional mechanisms to continue developing and applying the intersectional and regional standards on the right to participation and information, including strengthening collaborations with your sub-regional bodies and, when applicable, to harmonize the standards and existing standards. 6, boost coordination and complementarity between national, regional, and international mechanisms to effectively protect and rapidly respond to cases involving attacks against environmental human rights defenders. It is exhausting for defenders to trigger these various mechanisms, and I think that some ideas that have been shared already in this panel this morning could be an alternative, like maybe creating like a task force or something that could actually promote the protection of all these mechanisms on the different strengths that they have. 7, monitor the effective implementation of provisional and precautionary measures that they aim to protect environmental defenders. Many cases of murders and attacks against defenders involve individuals and communities who already enjoy these protection mechanisms. 8, guarantee that regional and international mechanisms have enough resources to ensure that environmental defenders and communities can use these mechanisms. We are in a liquidity crisis, but we cannot make that this crisis is also targeting the most vulnerable, the defenders. 9, ensure meaningful and safe participation in regional and global environmental governance. We cannot accept that defenders are being outnumbered by corporations in these spaces, or that defenders are subject to reprisals by engaging before, during, and after these environmental and climate forums take place. The lack of visas or the lack of opportunities and financial support to attend these forums is also not acceptable. And 10, to establish measures to hold corporations and financial institutions accountable on cases involving environmental human rights defenders. This includes also the extraterritorial obligations that could emerge in these cases. And to conclude, I just want to say that participation, access to information, and protection of defenders are interlinked pillars of environmental and climate democracy. We cannot advance the right to clean and healthy and sustainable environment if we don't protect those who are actually defending that right. Thank you.
Thank you so much, Ulises. This was so helpful, and in a way, you've provided us the universe, I think, of protections for environmental human rights defenders, looking both at the series of attacks, which we've heard, and how that is taking more and more legislative or even judicial form. And that in itself is undermining our democratic processes. And it's really important to see the systemic, I think, consequences of that. And maybe an opportunity for me to mention that only in less than 2 weeks, the UN, the periodic UN Forum on Democracy and Rule of Law will focus on climate change, and we have another opportunity to really go even deeper in those questions. But crucially, I think the other element that you have highlighted very powerfully is also how the protection of environmental human rights defenders needs to be very much at an early stages of prevention, and really looking at the framework of national and international laws relating to the environment, where we've seen that regression on environmental protection, but also any other areas of law that, as you say, either is not effectively targeting corruption or may allow for corrupt practices or the corporate capture. And so in a way, the whole aspect of kind of areas of intervention and why it is so important for us to share notes and really be aware of who's working at which point of that kind of full scale from kind of upstream to downstream attacks to environmental human rights defenders. And maybe also something that you have reminded me a few months ago, as you were supporting the preparation of some of my reports, also thinking about the role of judges, including national judges, and how they can play a role both in that recognizing and dismissing slaps. This is something that the UN Special Rapporteur on the independence of judges has already specifically recommended. The role of parliamentarians and what is their role in ensuring that kind of early stage protection as part of legislative reform and legislative developments. And maybe the final point is that how other special procedures are now more and more finding themselves to contribute to this. And I would just call attention to 2 recent reports, one by the UN Working Group on Enforced Disappearances, which is very much focused on essentially environmental human rights defenders, and also a recent report, I think, by the Working Group on Mercenaries, and about how much there is reliance on mercenaries for some forms of attacks that environmental human rights defenders are either facing or some of the developments on the ground that they are opposing. So really important to bring all these pieces together and making sure we are not, we're all aware, I think, of also the normative clarifications, the recommendations that are emerging across a much broader, I guess, set of human rights experts and actors as these attacks and the full range of reasons for those attacks is becoming clearer and clearer to the whole human rights ecosystem. So thank you so much for that, and I'm sure there'll be important reflection as we open the floor. But before doing that, we still have a very important contribution to the panel, Mr. Andrzej Mancewicz, advisor to the Office for the Commissioner for Human Rights of the Council of Europe, will also share with us from his vantage point what are best practices and challenges regarding the right of access to information, participation, as well as protection of environmental human rights defenders and possible areas of collaboration. So we very much look forward to hearing your insights. Thank you.
Thank you, dear Chair, Ms. Mojera, dear Special Rapporteur, Mr. Forst, Fiona, Ulysses, dear friends. Thank you for having me on this panel. And I would like to say on behalf of the Office of the Commissioner for Human Rights of the Council of Europe a couple of words on actions and priorities for action in the future by the Commissioner of the Council of Europe when it comes to protecting environmental human rights defenders. I think traditionally, by virtue of the Commissioner's mandate, one of the priority lines of action has been to promote human rights standards and mechanisms, and I think it's fair to say that for many years now, successive commissioners have been vocal advocates of the Aarhus Convention, which almost all Council of Europe member states have ratified. And our office has also been very much in support of the establishment of the mandate of the UN Special Rapporteur under the Aarhus Convention, seated next to me. And in addition to this, the Commissioner also promotes accessions to a more recent document, instrument of the Council of Europe, which is the Council of Europe Convention on Access to Official Documents. It's known as the Tromsø Convention. This is the first binding international legal instrument to recognize to everyone the right to access official documents held by public authorities. I think this is an instrument that encourages greater transparency also in matters related to the environment. And the Commissioner has also pledged to support the newly established Council of Europe strategy on the environment, and especially the pillar on supporting and protecting environmental defenders and whistleblowers. And in practical terms, I think this is likely to translate, for instance, into encouraging ratifications of the new Council of Europe Convention on protection of the environment through criminal law, which acknowledges the critical role of victims, witnesses, and whistleblowers in the process of prosecuting environmental crimes. And one other thing I wanted to mention that has emerged after recent country visits of the Commissioner is the reflection of the realization by the Commissioner that there is often on the part of key actors working on the environment, especially in the executive parts of governments, a certain lack of knowledge of the human rights instruments of the Council of Europe and more broadly. So I think the role of the Commissioner will also be going forward to raise awareness on how on clarifying legal obligations emerging from human rights standards to actors at the domestic level who work exclusively on environmental issues to sort of bridge that gap and connect the two worlds. Now, another priority for the Commissioner over the past years has been to stand up for environmental human rights defenders' rights to right to peaceful assembly, including peaceful environmental protests that has been already mentioned in this panel. For several years now, the Commissioner's Office has been observing a general trend of shrinking space for peaceful assembly across the Council of Europe area. And in response to this, in 2023, the previous Commissioner, Dunja Mijatović, has published a so-called human rights comment to throw a spotlight on the issue of crackdowns on environmental protests in Europe, with recommendations on how this should be tackled. Commissioner Mijatović and the current Commissioner, Michael Flaherty, have also been raising this in their dialogue with member states, and some examples involved letters that were sent, for instance, to Azerbaijan in 2023 about disproportionate use of force by police during environmental protests, or a more recent letter sent last year to Italy about a problematic piece of legislation that, among other things, could be interpreted as targeting environmental protesters. This year, following a country visit to North Macedonia, the Commissioner has called for supporting environmental human rights defenders through improved access to funding and also protecting them against vexatious lawsuits, so-called SLAPPs. And this work is, of course, complementary to the work of the Aarhus Special Rapporteur and also the UN Special Rapporteur on human rights defenders and other special procedures. One thing I wanted to mention here also, this has been mentioned previously, the initiative for a future European Forum on Environmental Defenders that Ana Paula also gave us some details about. We've been part of the meeting last year in Brussels, and this is something that we would very much like the Commissioner to be involved in. So we're very much in support of that. And lastly, one point maybe on an area for priority attention that I think emerges from our interactions with environmental defenders is this has been mentioned here in the panel. This is to do with the stigmatization of environmental human rights defenders. A Council of Europe study on the stigmatization of NGOs in Europe that was published in 2024 has found, in particular, environmental NGOs to be the target of such harmful trends. And I think this stigmatization and hate speech are especially harmful to the youngest environmental human rights defenders, many of them children. I recall being a couple of years ago on a panel discussion at the Council of Europe with some youngest environmental defenders, and they complained about being targeted by offensive comments, derogatory labels, hate speech, frankly, coming often from highest ranking public officials, both on and offline. And this is something that they found particularly difficult to deal with. I think that the asymmetry of this is evident. And they called for help in addressing the impact that such harmful narratives may have on their mental health. How to brace for this, how to prepare for this, how to deal with this. And I think this is something that deserves to be mentioned as an area that may require a bit more attention going forward. Thank you.
No, thank you so much. Very thoughtful contributions to our conversation. And maybe just to complement, I was thinking about this point around the lack of knowledge of human rights instruments, and it'd be interesting to think about which areas of executive, our own understanding also of where environmental human rights defenders are active. So climate measures, ocean measures, of course, Astrid's report this year very much raised the profile of marine governance as an area of human rights protection. But I know from my own engagements of fisheries department and other departments might be among the ones that might not be fully aware of human rights instruments and approaches. And there may be a wider maybe mapping to be done across executives about areas where I think human rights education and training may be essential. I was also thinking about this point on access to funding, so crucial, and something else maybe linking to Ulysses' point around leadership, agency, and vision of environmental human rights defenders is also recognizing them as maybe as recipients of, for instance, research funding and being co-researchers or lead researchers in efforts to, also consolidate their insights into what may become then the evidence base that leads to changes in education, in decision-making, in the evidence base for activities that around, all the steps that we need to take to protect the human right to a healthy environment. And of course, feeding then their insights and vision and that legitimization through research into education. And finally, I think that point on mental health is crucial. Dr. Na at my university at Durham has done some really important work of, I think, several challenges that environmental human rights defenders, particularly from that intersectional lens, face in terms of mental health. I think that's very true for children defenders, but also for women defenders and again, indigenous defenders. And the mental health support could be so crucial also to support the longevity of those movements. And again, the alliances among them. And unfortunately, often some of the discrimination may be faced even within those movements for all sorts of reasons. And it is also very harming and can have a long-lasting negative impact on the whole cause as well as on the individual defenders. So I think that I would suggest that might be another point that we can consider in our recommendations, the connection to mental health and thinking around funding and support for defenders, a lot that can be learned from one another, and also that may be connection with research as well. And I was just wondering, Michelle, if you wanted to say anything about also your work on clarifying the right to peaceful protest. I thought there was a really important contributions you made, I think earlier this year or last year.
Yes, very briefly, because time is running.
Yes.
And we'd like to give the possibility to the audience also to provide comments or questions to the panelists. Yes, in fact, when I started with the mandate in 22, I traveled across many countries to meet with defenders. I was struck by the many defenders that came to me saying that they have been facing strong attacks by politicians, by the media, by the courts, when they're trying to simply to exercise their rights to peaceful protest. And many of them were those who are using new forms of mobilization, like you call civil disobedience, going their hands on the floor or blocking access to airports. And that's why we decided to do a sort of empiric research across countries to get more information, recommendations coming from defenders themselves. And that led us to develop a position paper of the mandate on the right to peaceful protest and civil disobedience. And now I'm presenting in a couple of weeks now to the meeting of the parties what we call guidelines on the peaceful right to protest applied to civil disobedience. And the document will be soon, hopefully, Fiona, next week, available on the website of the mandate, in which you will find a strong document, which is it's not a binding document. It's there to guide states on how they could approach those who are trying to use the right to peaceful demonstration and are facing so many threats and attacks. And one of my expectations after the presentation of the report to the parties will be also to try and find ways to organize national workshops to look at how we could develop local national mechanisms to implement some of the provision of the guidelines. I've been already discussing with some states on this, but that's something that we'd like to really develop with other countries.
Oh, thank you so much. And I think another important area for also cross-regional learning. I see a hand in the audience, so thank you so much. Please, you have the floor, and with that we can open the space for dialogue.
Thank you. I am Abdelgawad Ahmed, lawyer, and I'm present Arab Council for Human Rights, NGO. I will complete by Arabic, if translate. يعني شكرا على هذا الحدث الهام المتعلق بالمدافعين عن حقوق الإنسان في مجال البيئة والصحة والبيئة السليمة، باعتبار انه الحقوق البيئيه والحق بالصحه والبيئه السليمه هو من اهم الحقوق لانه مرتبط بالحق في الحياه. الحق في الحياه والحق في الوجود مرتبط بحق الصحه وحق البيئه السليمه. ليه سؤال للخبراء المتعددون على هذه المنصه فيما يتعلق بالحديث عن الدفاع عن المدافعين عن حقوق الانسان في مجال البيئه والصحه. المدافعين عن حقوق الانسان في مجال الحقوق السياسيه والتعبير والحقوق الاخرى يعني لديهم تاريخ كبير جدا ولديهم اليات ومصادر متعدده في الحصول على الحمايه في اليات متعدده اقليميه ودوليه. لكن الا ترى معي واحب اسمع الاجابه ان المدافعين عن حقوق الانسان في مجال البيئه والصحه بيواجهوا طرف رجال اعمال، اصحاب مصانع، اصحاب صناعات، شركات تجاريه بتدمر الصحه، بتدمر البيئه. الطرف المعتدي هنا غير الدوله، غير الشرطه، الا ترى معي ان احنا محتاجين كان جي او كمنظمات اقليميه او منظمات دوليه او امميه، احنا محتاجين نبحث في اليات مخصصه للمدافعين عن حقوق الانسان في مجال البيئه والصحه، لان الطرف الاخر مختلف، طرف لديه موارد، طرف قوي، طرف بيبني مصانع، بيعمل اعمال، بيصنع ادوات او مواد متعدده بتضر بالصحه، بيعتدي على البيئه، في تلوث، فهو اقوى من الدوله في التعدي. انا اتمنى او انا اعتقد ان احنا محتاجين نغير اليات المواجهه، اليات الدعم، لان في اختلاف في الشخص الطرف الاخر. احب اسمع يعني بالتعدد الخبراء الموجودين رايكم في هذا الامر. شكرا.
Thank you so much for this really important question. I might just look around the room to see if there's a few more questions, and then we'll go back to the panelists. Yes, please.
Hello. Not so much a question, but a comment. As I was listening to the panel and listening to the discussion, what can courts and judges, the judiciary, do in protecting environmental defenders, right? Because we're a court, we're a young court, and we're not making policy, we're not legislating. So I was just wondering about that. And also just to add to the discussion. So last year, the court, our CCJ, Caribbean Court of Justice, we're a young court, we only really received our first matter, a first appeal concerning the environment, which touched on environmental issues last year, and it really had to do with the permissibility of granting a production license for drilling of oil and production of oil, right? And it was brought by a private citizen who brought it through the system. So he went first instance, he lost there. Second, he appealed it, he lost there. He went back down to the first instance, he lost again. He brought it all the way back up to us, and he lost again. Well, we dismissed the appeal, but what the court did in the granting of costs, we didn't make a cost order against him because we realized the importance of the litigation that he brought. It was in line with the ESCASO agreement, which encourages public participation, and we really, well, the court decided, looked at it and said, well, he even confirmed some important issues about how the legislation should be interpreted, and the fact that, you know, we want to ensure transparency in operations and things like that. So this was important because we actually, well, in Ghana, one of the government ministers actually was encouraging the courts to impose high cost order to prevent frivolous and vexatious cases. So it was good that at the highest level, at the CCJ level, right, we basically said that we're not going to do that because we want to encourage public participation. We want to encourage these type of cases. We understand the importance of that. So that's just also to add to the dialogue that I want to bring to the panel's attention.
Yeah, thank you so much for these contributions, and I'm sure the panelists can add. I see another flag on the side of the room.
Okay.
I'd like to just make response to the statement of the member of the Council of Europe regarding the use of excessive force by police in Azerbaijan that you have mentioned in the letter. That I would like to mention that government of Azerbaijan takes the allegations regarding use of excessive force by law enforcement very seriously. We emphasize the protection of human rights and rule of law remains central to our commitments, including those undertaken as a member state of the Council of Europe. All claims of disproportionate actions by police are subject to review under national legislation, and relevant authorities are mandated to investigate any substantive misconduct. At the same time, law enforcement is obliged to act in situations where public order and safety are at high risk, always with the aim of ensuring necessity and proportion. And we will follow up with our Council of Europe in the later dates. Thank you.
Thank you very much. Please, yeah, you have the floor.
Thank you, Madam Chair. I would like also to congratulate the panelists for their insight and just share also a perspective from the ECOWAS in general when it comes to NGOs, civil society organizations organizing themselves and trying to push really for the environment protection and also the defenders of human rights and also the environment. We have in ECOWAS actually two umbrella organizations of civil society. We have the WANEP, which is the West African Network for Conflict Prevention and Peace Building. And we have the West African WATSOF, which is West African Civil Society Organization, which has 12 thematic groups. One of them is environment and climate change. And actually what happened is that these organizations, they are really involved in policy making. So, and they are involved also in the implementation of the rules, the regulations that have been adopted. But we have also some other organizations that are more court proceedings oriented. We have, for example, the Institute for Human Rights and Development, which is based in Banjul, Gambia. And their role is really to go and visit the communities affected, for example, by these situations, and try to gather all evidences. And then they build themselves the case. They help the communities build the case and then also prosecute the case before the courts. So we have organizations like that just to share, because the concerning the forum to say that we also have this kind of organization, although they always complain about inadequate resources. Thank you.
Thank you so much. I'm aware of the time, so just checking if there's any additional question. Otherwise, I'll give the floor back to the panelists, maybe in reverse order. Andre, can we start with you?
Yes, thank you. To reply to the question by the gentleman to my right, I think it is true that environmental human rights defenders are, a very specific subcategory of human rights defenders. But I think what is out there is definitely limited in terms of what mechanisms are available to protect them, and we've heard comments about limiting staffing and funding available to what's in place. But I think in a way it's useful for environmental human rights defenders to be able to lean on mechanisms that are available to human rights defenders more broadly. And that was the point that has been made by the previous commissioner, Dunia Mijatovic, in her third-party interventions filed before the Court of Human Rights in Strasbourg, or in her human rights comments, that environmental defenders are human rights defenders, and I want to repeat this because this is sometimes still being challenged. I think it's important to stress that environmental human rights defenders should be considered as human rights defenders, even if they might not necessarily self-identify as such. And in that sense, this opens up possibilities to use mechanisms that are available to human rights defenders more broadly, and I think that's an important avenue. And just to reply to the delegate of Azerbaijan, maybe to give more context about the work of the commissioner, I mentioned a letter addressed by the commissioner. This letter has received a reply filed by the Azerbaijani authorities, and since the basis of the commissioner's work is dialogue with the member states, both the letter and the reply are made available on the website. So that's in the spirit of cooperation dialogue that our work is in which our work is grounded, and that's just to say that we really appreciate this kind of dialogue with Azerbaijan and other member states.
Thank you very much. Ulysses?
Thank you, and thank you so much for your interventions. I really appreciate it and really feed on the discussion. I just wanted to mention, maybe just to quickly respond on some of your interventions, is that, yes, it's true that maybe right now there are many mechanisms, regional mechanisms for rapid response and protection of defenders. But unfortunately, we need to see this also from the perspective of the defenders who are at the front line. Like, some of them, first, don't know about these mechanisms. Second, they are exhausted. I mean, they are dealing with the day-to-day situation in their territories. So the last thing they want to do is to trigger 4 or 5 mechanisms just to see if they can be protected. So we really need to make sure as well that from those who are in this privileged position here, how do we make sure that these mechanisms are available, or at the same time really respond, that we are not creating extra burden to them. Sometimes when we discuss with them and we say like, okay, you need to document your case, they don't do it. I mean, they are overwhelmed. They are documenting the case of the pollution of the river, the land grabbing. They have normalized that kind of violence and intimidation. So a lot of support needs to be given also to those who are in the ground. So the easier we can also give them the possibility to access those mechanisms, the better. The second is that, unfortunately, and I understand the reason, most of these mechanisms require to individualize the protection or to individualize the person who are actually asking with this rapid response mechanism. And this really departs from the collective approach that some cases require. And this is also very difficult because sometimes by triggering a mechanism, you are already identifying this defender as defender. And sometimes that boosts even more intimidation, more harassment. So how to also move forward, and these mechanisms create collective protection or collective approaches to also make sure that by individualizing the cases, we're not also putting them at risk. And on the other hand, what we have seen that actually saves lives, what actually makes sure that the defender is not targeted, is the self-protection mechanisms. So that's also something that we need to start incorporating as well. Not like how to also make sure that we fund and we support that self-protecting mechanisms, because community-based protection is what actually is saving their lives. And this is connected to mental health, that what you were mentioning, Elise and others. During our consultations, we also saw a lot of mental health issues that arose, and this was particularly present with indigenous peoples. There is some increased number of cases of suicides among indigenous peoples because they had failed to protect the environment. And this is not connected only with the mental health, but also with the spiritual connection that some of these defenders have with the territory. When they see that they have failed, they have nothing else that sometimes to record to this kind of measures as suicide. So I support having maybe recommendations on that direction. And maybe finally on the role of judges and also lawyers, I think that in this case, you have also the possibility to protect rule of law, to protect that as well, that there are strong institutions and that actually you abide by not only national, regional, but also international rules and legislation. So the fact that you are here in this forum and to hear all of these different developments, I think the next step is to apply these developments. And that's a way as well in which you are going to make sure that there is access to justice and also accountability. Because then you will be applying the most recent international and regional standard when you are deciding on this kind of cases. So I will leave it there. Thank you.
Yeah, no, thank you so much. Well, Fiona?
Thank you very much for all your very thoughtful reflections. I would like to begin by the gentleman from ECOWAS to ask whether the network from civil society that helps preparing cases, do they provide legal support and legal advice for people who may be facing slaps? Because if so, that would be something that we would be very interested to talk to you about, to learn what practices and procedures and assistance you have in your region to assist people who are facing slaps. Secondly, with respect to the gentleman who raised the issue about the fact that in the environmental area, actually defenders are most at risk from corporations. Yes, the challenge, of course, that faces the human rights obligation is placed on the state itself. The Compliance Committee of the Aarhus Convention has held that under Article 3.8 of the Convention, which is the provision that Michel Forst spoke about, the parties to the Convention are also liable for persecution, penalization and harassment carried out by private actors that the state doesn't take the necessary measures to prevent. So there is a little bit of light there that may be helpful, but the obligation is still on the state itself. Then turning to the judiciary question. So the first thing I would say would be if there is possibilities in your judicial training scheme to invite local civil society who are working on these issues to come and speak to the judges, so the judges are aware of the issues that their communities are actually facing. That would be the first thing. The second thing during judicial training would be to keep the judges being informed about the developments that are taking place in other courts of tribunals, and so that they can see what is happening, and then to encourage them to cite that case law and those international standards in their judgments, because by doing so, we actually managed to lift all votes. Thank you.
Thank you so much, Fiona. Michelle?
Thank you, Elisa. I would like to maybe to complement what has been said by Fiona on the role of companies. As you already know, special rapporteurs do receive already quite a huge number of complaints coming from defenders that say that the most dangerous actors are not the state but companies. And if you read the report mentioned by Ulysses from Global Witness that record every year the number of killings of defenders, so you would see that most of them have been killed by or with the support of companies or private actors or securities companies that protect companies operating outside their territories. And that's something which is for me a matter of concern as well. And because we did receive already complaints coming from defenders in that scope, we organized 4 consultations in the last couple of months, one in Togo, one in Nairobi, one in Bangkok and Bogota, inviting only defenders that were facing threats by companies with a view to better understand the type of threats they provided to us and to provide also guidance to states and to companies on how to deal with those attacks. And my report that we presented again at the meeting of the parties in a couple of weeks now, the report on consultations and trend, there's a specific section dedicated to those defenders facing threats coming from companies. And there's a lot to do, not only to simply implement international obligations, but also to look into the new directives that have been developed by the EU, and it is unfortunately not really well developed. Now to follow up on what has been said on the role of judges and the judiciary, again, that's something which is a matter of concern for me. And again, there's a lot of possibilities for judges simply to dismiss what we call slaps, in fact, that are so common and so commonly used. And luckily in Europe, we have now the anti-slap directive that has been adopted. We have the good guidance tool from the Council of Europe also that also helps companies to assess whether or not when they try to sue defenders or organizations, it will not be dismissed because it's a slap, and simply assessing before going to court if it's a slap or not. That's something which helps also defenders to be better defended. Lastly, I'm impressed by the fact that when I'm monitoring trials at courts, the lack of understanding by judges of international obligations from the countries. And clearly there's a lack of training at domestic levels on judges, and we need to push for more training on international human rights law for judges. I did one training in France at the French School of Magistrates, by which we had 80 young magistrates that were really keen to better understand and to learn, saying that in their curriculum they are being trained in international human rights law. And again, that's something that we also need to push for, a better training for judges to better understand that the right to protest is protected by international human rights law, even if they break the law.
Great, thank you so much. I think we're at time, but just checking if the panelists have any final thoughts. Otherwise, I think I would just like to thank them and maybe ask the colleagues in the room to give a round of applause. It has been a really insightful panel, and I'm very grateful for all of you today. I think there's a lunch break now, and we'll resume again at 3 p.m.
Thank you, well done.
Yeah, I think, that was so great. I think we covered a lot of ground and some connections. I can't wait yet to read your guidelines. I didn't know that was coming up. So
Yeah, they're public next week.
I think if we can ask recording this lunch event.
Yes.